defender to the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the cases of the People versus Timothy Haslam.
Township.
Good morning, Your Honor. Christina Berry Deering requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney Ashley Londy.
Permission to practice is granted.
Your Honor, Christina Berry Deering for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Haslam. I suppose on the two cases he's already been arraigned on, ending in 04091621. Mr. Haslam, can you state your name, please?
Timothy Haslam.
All right, sir, you are up on two cases today. There is another case that is before the court that I'm going to arraign you on at this point in time, sir. And it's a two-count complaint that alleges that on or about October 26, 2024, at the location of Washtenaw Avenue and Gulfside in Pittsfield Township, Washtenaw County, State of Michigan. Count one alleges that you operated a motor vehicle without proper security or insurance as required by statute. Do you understand the nature of that charge, sir?
Yes.
It's a misdemeanor punishable by not more than 1 year incarceration and or not less than $200 nor more than $500 fines plus court costs. Do you understand that, sir?
Yes.
Count two is the offense of driving while license suspended, denied, and or revoked. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand the nature of that charge and its maximum penalty, sir?
Yes.
First question I have for you is, do you wish to be represented by an attorney?
Yes.
Public defender case.
Your Honor, on this case, I am, I'd wait for the reading standing to the charges. I would ask for another pre-trial. I did receive an offer from Ms. Londy. I just need some time to speak with that about Mr. Haslam, but we do have resolutions on the other two cases.
All right. 7-2, correct?
Yes, sir.
All right. So on this case, I'll set his bond at a $1,000, 10% bond. I'll adjourn the pre-trial on, this is on 7/21. I'll adjourn the pre-trial my next.
July 16th, 2025.
July 16, 2025, 9 a.m. All right, and that'll take care of that matter. And then on the other two cases, what's our resolution?
Well, on the case ending in 0409, that is a sentencing. I think the court set it for today for convenience sake.
Okay. Well, no, is it? I don't either. You're saying 409?
Yes.
I don't have that as a sentencing. Well, he did plead guilty as charged.
It was making JIS as a pre-trial, so I don't believe you have any sentencing information.
I do not. Yeah, it should be a sentencing. Okay, I see what the problem is. It's set as a pretrial, but October 24th, October 16th, 2024, he pled, referred him to probation. November, we came back, we had to re-refer him because he didn't do that. And then from that point in time, he has bench warranted or we've adjourned it out.
I think the PSI was completed with Ms. Polaro. I have one from May.
Brother, I did complete a PSI because Mr. Haslam was in custody. I can pull that to court would like to take care of that today. I believe it was a recommendation for credit for time served.
Yeah.
Well, he's got to come back on the 16th, so
Okay.
I'll just put this over to the 16th.
Perfect, that's even better.
We can do that. And what are we doing on the other matter?
The other one is going to be a double parking resolution, Your Honor.
That's correct, Your Honor. So I'm looking at count two of double parking. Case 241-1621. You accept that admission to double parking and you dismiss your original charge.
Mr. Haslam?
Yes.
All right. Do you admit responsibility to the fact that on or about November 25, 2024, location in Pittsfield Township, Washington County, State of Michigan, that you double parked a motor vehicle?
Yes.
Court will accept that admission to count 2. Count 1 is dismissed. That'd be fines and costs of $180. That'd be due 60 days after release.
Okay.
All right. Thank you.
Thank you.
Thank you, Mr. Haslam. We'll see you in a couple weeks. Court calls the case People versus Nicholas Stimmel.
Christina Rare, for the people.
And good morning, Your Honor. Rita Young, appearing on behalf of Mr. Nicholas Stimmel, who's also present by Zoom. Sir, would you state your name for the judge, please?
Nicholas Stimmel.
Good morning. All right. What are we doing?
Judge, I just received late yesterday afternoon the paper discovery and video discovery. I did send the paper discovery to my client, but we both need to see the video discovery before we decide our course of action. So asking for one adjournment of the pretrial.
Hearing no objection, I'll adjourn this matter to July 16, 2025, 9 a.m. Bond will continue. Thank you.
Judge? Ooh.
Yes. Yeah. Of course, you're not available. You're in trial in Wayne County.
Can we go further in July, please, sir?
I knew it when I called out the date. I said that she's going to tell me she's busy. What's my next date?
August 6th.
Next date is August 6th, 2025, 9 a.m. I'm not moving that, counsel. If
Got
you've
it.
got something set August 6th, you have them move it.
Yes, sir.
All right. On continue.
Thank you.
Thank you.
Mr. Stimmel, I'll give you a call. You can sign off now.
Court calls the case People versus Adam Soward. Excuse me.
Very hearing for the people.
I'm sorry.
This is Mr. Timothy Diamond, who is physically here. So
I can go see if he's in the hallway. What's the last name?
Diamond.
I.
That's the attorney.
Yes, sir.
Good morning, Your Honor. Timothy Dinan, P 49499, appearing on behalf of my client who is on his way here. Judge, he had a late start this morning. My apologies.
I'll pass it.
Thank you, sir.
Court calls the case People versus Kathy Johnson.
Ready, Your Honor.
That's a lot of people.
Good morning, Your Honor. Tim Hensick appearing on behalf and in the company of the defendant, Kathy Johnson.
Your name?
Kathy Renee Johnson.
All right. As to the arraignment on this, counsel, has he been arraigned?
Yeah, we only worked for sentencing.
I thought we were too. Let me pass this matter. My files. Court calls the case People versus Ricky Ballard.
Very hearing for the people. Ready?
Good morning, Your Honor. Robin McCoy, P63057, on behalf of Mr. Ricky Ballard. Your Honor, may we briefly approach?
Yes, Your Honor. That's the arraignment counsel.
He'll stand mute and waive the reading of the information.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea.
And Your Honor, I just want to make sure that the court is aware that my client, he has been taking this very seriously. He's had no prior conviction of this sort. So he's attending AA classes, and we did provide verification to the prosecution. He's scheduled for a substance abuse assessment on July 15th through First Step referral services, and he'll be attending an impact panel on July 14th at 7:00 at Bethesda. So we are still in plea negotiations, so we're requesting that this be adjourned so that we have, more time to try to work something out.
Adjourn this matter July 16th, 2025,
Wait,
9 a.m.
the 16th, will it be 9 a.m.? It'll be in person?
In person.
Okay, I have a Zoom at 8:30, but okay, that's fine. So 9:00.
As to bond.
Your Honor, we are requesting a sober link at this time. The defendant.
What is the alleged BAC?
0.179. He was pulled over for speeding 25 over the limit. No priors.
No accident.
No accident.
And Your Honor, he is taking this very seriously. He's gainfully employed, he's married, he has 3 kids, and his family is counting on him to deal with these issues. He had some trauma from his youth, so he was in counseling, and he's making efforts to get back into counseling to address these issues. So we would ask that he not be placed on a sober link at this time.
Defendant's bond is set in the amount of $20,000 personal recognizance bond. All other standard conditions, including no assaultive behavior. There should be no use of alcohol, recreational marijuana, or any illegal drug. I am going to order that the defendant report to the Department of Community Corrections for placement on a sober link testing device. I've signed that order. He should probably appear within the next 24 hours. And we'll see everybody on the 16th. Thank you. Court does call the case, people. Do I have us all there?
Yes.
Kathy Johnson. We call Kathy Johnson. My apologies for that, folks. My files should have been ready. All right. Sir, have you read over the pre-sentence report?
Your Honor, we have read over the pre-sentence report and recommendation. We have no corrections, deletions, or additions. I would like to make comments on behalf of Ms. Johnson before the court imposes a sentence.
You may proceed, sir. Was there anything from the people on this?
Your Honor, we would support and ask the court to adopt probation's recommendation as written.
All right. Go ahead.
Judge, with respect to the recommendation, it is fair, it is appropriate. However, there are some things the court should know. One, this incident was triggered by a personal health scare for Ms. Johnson. She had a diagnosis of a breast cancer potential, and this particular event comes on the heels of 2 that occurred more than 22 years ago. And there have been no appearances in court. There have been no steps taken by her since back in 2001 and 2002 on the previous situations. Kathy works 2 different jobs, Your Honor, to support herself. Coming here today, she has made arrangements to immediately serve at least the minimum jail sentence, taking time off from her jobs. I have come to know her since being involved as her attorney as a very responsible lady who understands the gravity of what occurred here. She has participated in Dawn Farms program. She has been here cooperating with the court, with probation, with whomever at every step of the way. I think, Your Honor, that the court should show some kind of leniency in terms of the fines and costs to allow her time to make payment. They total over $2,000, 24 months of probation. She just needs time to pay. And Your Honor, I believe that she would like to make a statement on her own to the court.
Very
You can go ahead.
My name is Catherine A. Johnson. I realized I made a mistake because I could have harmed other people. And I've been attending AA meetings, and I put myself in Chavez firm on my own. And I've been working 2 jobs. And I realized I made a mistake, and I'm sorry for what I've done.
Court does acknowledge it's not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart with the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, AA attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is the sentence of the court. You're placed on 24 months of probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, and $720 probation oversight fees. When can that be paid? How are you going to pay that?
I'm gonna pay it when I get paid, if I can. On a monthly thing, I would like to be on I would like to be on.
How much do you believe you can afford to pay of that per month, man?
At least $100 a month.
Pardon?
I could pay $100 a month.
All right.
My check is being garnished right now.
I think we'll be able to. All right. I'll set your payment plan at $100 per month. That will begin in August. It may be readjusted by probation just to make sure that you're going to be able to get that all paid prior to the point in time of the end of your probation. There should be no alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You'd complete the Dawn Farm outpatient program, including all recommended aftercare with status reports to probation. You're to attend 1 AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Mr. Allen. I'll order 365 days in jail, credit for 1 day served. I will remand you to the Washtenaw County Jail to serve an additional 4 days, and then the balance will be suspended. Defendant is remanded. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Alexis Berry.
Christina Berry for the people.
Assistant Public Defender Natalie Patewick, on behalf of Alexis Berry, who appears via Zoom. Can you please state your name for the record?
Alexis Berry.
Thank you, Your Honor. I'm respectfully requesting an adjournment. I have had a discussion again with Miss Berry yesterday, and I did discuss this with the people. I'm asking for an adjournment for Miss Berry to stay in compliance with bond and potentially earn a reduction in potential resolution.
I understand that. Would an August date work better for you then?
I believe so, yes, Your Honor.
During the matter, August 6, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
Court calls case People versus James Bowman.
Christina Berry for the people.
Assistant Public Defender Natalie Patewick, on behalf of Mr. Bowman, who is present via Zoom. Sir, can you please state your name for the court?
James Bowman.
Thank you, Your Honor. There has been an offer extended in this case by the people for him to plead to count one and in exchange count two would be dismissed. I have discussed that with him. However, I have discussed this further with the people and there's some information I'd like to provide them with and potentially come to a different resolution. I would,
July
thank you, Your
16,
Honor.
2025, 9 a.m. Bond continued.
Thank you, Mr. Bowman. You're all set for today.
Court does call the case People versus Jason Brooks.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Brooks. Mr. Brooks, please state your name for the record.
Jason Brooks.
All right, thank you.
And we're asking you to set this for final settlement, please.
Jury final settlement conference will be set for August 8th, 2025, 9 a.m. Jury selection, if necessary, August 11th, 2025, 8:30. Both of those proceedings are in-person proceedings. Thank you. Bond continued. Court calls case People versus Kyle Burmeister.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burmeister, who should be present via Zoom. Sir, can you please turn on your camera, unmute, and state your name for the court?
Kyle Burmeister.
I'm trying to turn the camera off. I'm here.
Can you please state your name, sir?
Kyle Burmeister.
At this time, Your Honor, the people move to dismiss.
Okay.
No objection, Your Honor.
Case is dismissed.
Thank you.
Thank you, sir.
Thank you, Mr. Burmeister. You're all set.
Thank you.
Court calls case People versus Tario Abdul Salam.
That's a lot of the people.
Abdul Salam, not present. I'll issue an order to show cause. Court calls the case of the People versus Abdallah Bader.
Christina Bear.
It's already a show cause for penalty. Bader. No response. A bench warrant will issue for the defendant's failure to appear. Bond in this case will be set in the amount of $5,000, 10% bond. That warrant will issue immediately. Court does call the case of the People versus Luke Barrett. Luke Barrett. No response. I'll issue an order to show cause. Court calls case People versus Joseph Bogan.
That's a lot of the people.
Bogan. No response. I'll issue an order to show cause. Court calls case People versus Richard Bauer.
That's a lot of the people.
Richard Bauer. No response. I'll issue an order to show cause.
Thank you. All right, so just a few things. Mr. Dillon, you understand that you're waiving your right to assert specified grounds as a basis for removal. So you can't, or recusal, so you can't say, I can't hear your violations because I know you, right? Okay. And you understand you're coming into the program and you've been here for a minute, you get the requirements.
Yes.
And you've been doing pretty well so far, it looks like. So, okay. I'm going to accept you in. I'll give you your sentence and then we'll do this violation. Okay. You have a $900 probation oversight fee, $500 treatment court cost, $20 clinical fee, $100 alcohol assessment fee, $300 in costs that are collected for the Third Circuit Court, $53 state minimum fee collected for the Third Circuit Court, and a $75 crime victims' rights fee also collected for the Third Circuit Court. So you have a total of $1,948. You can have a payment plan over the course of your probation, and you'd pay that at the rate of $163 a month beginning June 15th. You'll enter the treatment court program for 22 months and follow all requirements in the handbook. Have you read the handbook?
Yes.
Okay, read it again.
Yeah, I will.
Okay. You'll attend a complete substance abuse treatment program and follow all recommendations of your therapist. You'll attend your 12-step meetings or other similar organizational meetings 3 times per week as directed by probation with verification to the probation officer. You'll obtain and maintain your sponsor or a mentor within 60 days. You'll submit to random drug and alcohol testing as directed. You'll abstain from the use or possession of alcohol, controlled substances, or paraphernalia. No prescription or over-the-counter medications without approval from the probation department. Follow all steps outlined in your individual development plan that will be written in phase 1 of the program, including any additional programs deemed necessary by the judge. You'll remain out of establishments that primarily sell and serve alcohol and do not enter areas known for drug or alcohol use. Do not surround yourself with drug or alcohol using peers. No driving unless you have a valid license. You'll attend and complete any other ancillary services that are deemed warranted. You'll attend the Victims Impact Panel within 60 days. You have 240 hours of community service in the city of Taylor or as directed. You'll attend the alumni group while you're in phase 1, and you'll attend a minimum of 10 Northwest Wayne fan meetings in phase 1, phase 2, and phase 3. So before completion of the program. Okay?
Okay.
Let me see what I'm supposed to sign. Okay. Then we have a bond violation allegation that alleges you failed to appear for your status here on June 20th. You understand that allegation?
Yes.
Did you go over this bond violation arraignment and advice of rights form?
Yes.
Did you sign and date it?
Yes.
You understand you have a right to a hearing if you wanted a hearing where the probation department would have to prove by a preponderance of the evidence that the violation occurred? Are you waiving your right to a hearing?
Yeah.
Okay, to the allegation you failed to appear for status hearing on June 20th of 2025 at 8 a.m. How do you plead?
Guilty.
All right, I'll accept the plea. What happened?
It was just kind of a oversight, you know, I know there was a couple of Fridays there where there wasn't a status hearing and
The dates, yeah.
yeah, so I just,
Well, just so you know, in the
Yeah.
coming weeks, we have all kinds of crazy things going on with the dates because of Family Fun Day
yeah,
and time I have out of the building for a conference. So make sure that you bring your calendar in and go over that with Miss Grasso.
yeah.
Because there are, I mean, I'm even confused about the
No,
amount of
she's really good
changes.
about that, so I,
Okay, good. All right, you have to make it to that. You know that. They're
Yes.
really important. It's my check-in with you. And it's an opportunity for you to have some build relationships with other people in the sober community. So they're really important. But he's otherwise been on task with everything, right, Ms. Grasso?
Yeah, I think that, this was just an oversight. There was also an issue where I canceled my appointment because I was not here that day. And I think it set his weeks forward one. Yeah, so, but I mean, I messaged him while we were in status hearing. He was like, I'm coming, but he would have gotten here, would have been almost over, so.
Okay, yeah, all right, you've got a day of community service within 8 days, or I'm sorry, within 28 days. Ms. Grasso recommended 14, I'll give you a month to do it, okay?
Okay.
So you do 1 day of community service, and yeah, you have to be nimble with treatment court, right? So, all right. That's your verbal reprimand. Make sure you make it.
Okay.
It's important. And make sure you make it on time. All right, Mr. Dillon, you're all set.
All right, thank you.
Yep. Thank you.
Thanks,
Counsel.
Judge.
Yep. Do I have Randall here? Neville Randall?
He should be
Oh.
there, yeah.
All right, Neville Randall, can you turn your camera on?
Yeah.
All right, there we go. Thank you, sir. This is 2517150M, the People versus Neville Randall.
Good morning, Honor James Gazicki on behalf of Mr. Randall. The misdemeanor is going to be dismissed. Defense filed a motion that's not being contested. Prosecutor agreed to a dismissal. The ticket, Mr. Randall is requesting a formal hearing. I advised him since it's a civil infraction, the court will not appoint an attorney for that, and he's aware of it.
You understand all of that, sir?
Yes, ma'am.
Okay. That doesn't mean you can't retain an attorney, but it means you're not entitled to one under the Constitution and public expects.
Yeah, I understand.
All right, we'll set a formal hearing on that civil infraction and you'll receive notice of the date and the misdemeanors dismissed, sir.
Okay, thank you.
Yep, have a good day.
Thank you too.
Submit a positive PDT at the court. She denied it.
I think the court addressed that last week. She has some, I think she has 2 days community service as a result.
That's a little concerning though. Yeah, I remember that. And like, you don't look like someone who wants to go to jail, right? We talked about that. All right. And I think some supervision, I mean, heck, if not for that and the accident, I think we'd be in a different realm. So I do think some supervision is appropriate, but I don't think you need 12 months probation at all. So I'm going to reduce that down to 6 months, and I'm sure Mr. Fanto advised you if you comply with all the terms of your probation and you complete everything I asked you to do, you'd be eligible for termination at 3 months. Okay. You have to submit a request for it, but provided you completed everything that you're asked to do and you're not having positive tests at the court, I'd be inclined to grant it. So you have a fine of 300, court costs of 300, state costs of 50, and a crime victim's rights fee of 75. Those two are mandated by the state of Michigan. You have a probation oversight fee of $250. And you have your assessment fee of $100. If there's restitution, we will set hearing. Is she here? Mr. Stevens?
Hello? Yes.
Prior to me imposing the remainder of the sentence here, I'm sorry, I didn't realize you were here. Is there anything you'd like to say?
No, thank you.
All right, and Mr. Stevens, I'm just going to ask because he's here. Did you have a claim of restitution?
I sent the paperwork in, but I sent it in, I think it was like 2-3 days ago. I emailed it.
All right, so if we I haven't seen it. If
Mr.
we,
Keys indicated he hadn't seen it, but
okay.
just have him follow up with Mr. Keys, then we can set a hearing.
Yeah, do you know, Mr. Stevens, did you send it to Mr. Keys?
I don't believe so. I don't know if I have the proper email.
All right, was it Matt Zick?
Nope.
Okay, we'll try and figure out who it got sent to because we don't have it in the file. All right, so we'll set a hearing for restitution. Once those documents are located. You're going to serve 6 months probation. You'll have 2 days of community service in the city of Taylor. And that was part of your bond modification. You had 14 days to do those and provide proof. So you have to do that. You can talk to your probation officer about it. You're to abstain from the use or possession of alcohol or controlled substances unless prescribed by a physician, and documentation will be required. And that's for your term of probation. You also have random drug alcohol testing as deemed necessary. You'll submit to that testing at your expense. You'll stay out of establishments that primarily sell and serve alcohol in the bars and liquor stores. You'll attend the victims impact panel as directed and provide proof of completion. You'll complete an alcohol education course, provide proof, and follow all therapeutic recommendations. They'll explain that to the probation. You'll obtain and maintain employment, provide proof. I know you don't have any warrants and your prints have been done. I'm just reading it in the record, okay? You'll clear all outstanding warrants, if any. You cannot operate a motor vehicle without a valid license. And if you weren't printed, you get printed. So now, Ms. Washington, the ball's in your court. I'm giving you the benefit of the doubt, right? As long as you're testing negative and you complete this stuff, you'd be eligible for termination based on, the law. But if you continue to come in and you have positive tests, your probation could be extended. So it's up to you to keep the probation period, okay? Okay. All right. Anything else?
Nothing for your other. Thank you.
All right, thank you. All right, and Mr. Stevens, when we locate that information, or if we can't locate it, someone will reach out to you and we'll set it for a hearing.
Absolutely. Sounds great.
Okay. Are we ready now on Bennett?
We'd like to.
Am I all set?
Take
Yeah.
care of a couple.
Yeah, Mr. Stevens, you're all set. All right. We'll take care of it.
You guys have a great day. Thank you.
All right, thank you. Do I have Grove? Are we ready? All right, is that you, Mr. Gazicki?
Yes, Your Honor. James Gazicki on behalf of Ms. Holgrove.
All right, Ms. Horgrove, can you tell me your first and last name?
My name is Andrea Hargrove.
All right, I've entered a not guilty plea for purposes of arraignment, and then I see she has a valid license.
I
Yes, Your
do.
Honor. And she's
Right,
going
so
to
the
plead
next-
responsible of double parking, request
All
payment
right.
plan.
All right, so the misdemeanor case is dismissed, ma'am, since you do have a valid license. And it looks like the speeding ticket's being reduced down to a double parking. Double parking's a 0-point ticket, but it has a fine of $165. And the allegation is on 425 of 25 that you double parked in the city of Taylor. To that allegation, how do you plead?
Guilty.
Oh, are responsible or not responsible?
Responsible.
All right, I'll accept that plea. And it's a fine of $165. Can you pay? Oh, you need a payment plan?
Yes.
All right, I'll give you a payment plan of $50 a month. Ms. Hornbrook, if you're going to be late on a payment or you don't have the full amount, call the court and we'll work with you. And that way you don't end up getting a show cause or having late fees assessed, okay?
Okay, thank you.
All right, you're all set, ma'am. Have a good day. Okay, yeah, thank you. Do I have Beyonce?
Yeah, that's me.
All right. This is 25TA10363, the People versus Rose Yance. Ma'am, tell me your first and last name.
Rose Yance.
Oh, Yance. Okay, well, that's not as fun. Okay. Ma'am, you had this ticket here and it looks like you're entering a responsible plea to double parking.
Correct.
And that's alleged to have occurred on April 23rd of 2025 in the city of Taylor. How do you plead, responsible or not responsible?
Responsible.
All right, I'll accept that plea. Ms. Yance, do you need a payment plan or can you pay that off in 30 days?
Can I do a payment plan? But like, if like, let's say I have extra money more than a week or whatever, I can just go in and pay it.
Yeah, what can you pay on a monthly basis?
At least $50.
All right, you've got a payment plan of $50 a month. Did you hear what I just said to the person in front of you?
Yes, I did.
All right, if you're gonna be late, make sure you call us and that way you don't end up with more fines assessed.
Will do. Thank you.
All right, thank you.
You have
All
a great
right.
day.
You too, ma'am. This is 250952, the People versus Gimma Trucking.
Good morning, Your Honor. Neil Riddell, appearing on behalf of the defendant.
Hi, good morning, counsel. So I have a plea form from Miss Marino in the file. Commercial, that there's a mud flap ticket. Hold on.
Yeah, there's a related civil infraction file.
Yeah, let me find it real quick. The tire's out of service with a fine of $510. Is that correct?
That's correct, Judge. Under the proposed agreement, my client would plead responsible to that. And the 250952 would be dismissed, as would be the balance of the charges in the 25 TA 07509 series of files. A, B, C, D, E, F, I think.
All right, you have authority to enter into that on behalf of your client.
I do.
How do you plead on behalf of your client to that allegation that's alleged to have occurred on April 1st?
We're responsible.
All right, I'll accept that plea as knowing and voluntarily given. There's a fine of $510. Can your client pay that within 14 days or do you need 30?
Oh, 14. Thank you.
All right, 14 days to pay. Thank you, counsel.
Thank you. Take care.
All right. Job Site Sources Incorporated. Counsel, good morning. Can I get your appearance?
Thank you, Your Honor. Jeremy Pickens on behalf of Job Site Services. And the owner, Todd White, is also here present today, Your Honor.
All right, good morning. So I have a plea form from the prosecutor that there is a stipulated fine of $2,300 on the A file. And in exchange, the B and C files would be dismissed per the plea. Do you have authority to enter into that on behalf of your client?
Yes, Your Honor.
All right, to the allegation on March 24th of 2025 in the city of Taylor, your client had an overweight commercial vehicle. How do you plead?
Responsible for the citation.
All right, I'll accept the plea, dismiss the 2 other cases. It's a fine of $2,300 and your client has 30 days to pay.
All right, thank you, Your Honor.
All right, have a good day. Thank
All
you.
right, you too.
I have the Asorial file up here, but nothing. Okay. All right, this is do I have Mr. Leo Baker?
Your Honor, Mr. Lustig is still in my breakout room. He does have a matter that's scheduled for this afternoon, so I was pulling that so we can do both since he's here.
Okay,
So
great.
we'll be on.
All right, then I'm gonna go have a bench conference on this other matter.
Got used to that myself.
Do you understand the allegation?
Yes, Your Honor, I do.
Okay, and did you go over your advice or rights with your attorney?
Yes, I did, Your Honor.
Did you understand your rights?
Yes, Your Honor.
And did you sign and date the back?
Yes, I did, Your Honor.
All right. Mr. Fanto?
And as we discussed, she appeared in the afternoon as she normally tests. She didn't realize June 19th was a holiday, and quite frankly, most of the time I don't either. I haven't got used to that myself, so that's why. And she immediately communicated with Ms. Grasso what the issue was. She has been testing at the increased testing, and all her tests have been negative.
Did she show up into our community service day in her last violation?
She did.
Okay, all right. Look, last time we were here, I told you you were cruising to go to jail.
Yes.
But Miss Bennett, let me start with this. To the allegation you failed to appear for testing on June 19th, how did you plead?
Guilty.
Okay, I'll accept the plea as knowing and voluntarily given. Ms. Bennett, I'm giving you the benefit of the doubt, and I'll tell you why. It's a brand new holiday, and people that don't work in courts or the government might mistake that. And my understanding is you showed up and that you had contact with Miss Grasso about the missed test. But Miss Bennett, there is a way for you to test when our facility is closed, if you miss, and you need to talk to Kara so you have that information. So next time this happens, which hopefully, knock on wood, it won't, but if it happens again, you know how to respond. You know what you need to do. There are testing facilities you can go to that we are approved, and you could just drive to one of them and they have extended hours, and sometimes people have to do that. I mean, you're supposed to be here for testing, you're supposed to do that, but life happens sometimes. And if you are aware of how to fix that, you won't end up in front of me, okay?
May I say something?
Yeah.
I don't have a vehicle, so it's kind of hard for me sometimes to get rides. I have to rely on finding a ride sometimes, and when I first got on probation, she did tell me that if the court was closed, that we were supposed to go to the police station. I went to the police station also that day.
They don't do
and
testing,
they
they'll
said
do
they didn't
PBTs,
testing.
right?
Correct. So
Right. I mean,
contacted
if she doesn't have transportation, what about the testing facility in Lincoln Park for oopsies?
So when I originally met with her, I told her about that she could do the PBTs of the police department. If she missed a drug test and she couldn't drug test anywhere else, at least go do a PBT at the police department, just to show some type of effort.
Or show up the next day.
The closer facilities around, I believe, close at 7. Just like.
Okay. At least if it ever happens, and if I were you, show up the next day and test. Don't wait 3 days until your color gets called again, because then you can show me like, it's not because I'm using, it's because this was a federal holiday I was not aware of, right? Like, don't wait 3 days to show up. Show up, because then when you come in, Kara's gonna tell me she showed up the next day when her color wasn't called and she had a negative drug screen. Like, and that's easy, and it's a way to avoid going to jail.
Yes, Your Honor.
So
I understand.
I understand it's a holiday. I understand a lot of people don't necessarily recognize it as a holiday yet because it's only been 2 years. So, or 3. So I found you guilty, or you pled guilty. You're gonna do a day of community service within 14 days. And Miss Bennett, I'm holding that day in jail in abeyance. That means if you violate in 30 days, I'm making you serve that day. It's hanging over your head. But as long as you're doing everything you're supposed to do for the next 30 days, it just disappears.
Yes,
Okay?
Thank you very much.
So if you have 30 days, no violations.
Yes, Your Honor.
Okay?
Thank you so much.
Thank you, Judge.
All right. This one's on top. Is that what you just said?
I put the new ones up.
Okay, okay. All right, I've got next 25TA11880, the People versus Leo Laker.
Good morning, Judge Shackelford, Dove Lustig on behalf of Mr. Laker, my dear friend's son, who has received a stern talking to, but I do have the agency authority to enter into the plea of responsible that's before you on his behalf.
How old is he?
He is, I think, around 20. Actually,
He's got,
is a
the
perfectly
double-
clean record.
Okay, the prosecutors offered a plea agreement down to a double parking,
Correct.
and you said you have authority. How do you plea on their behalf, on, Mr. Laker?
Responsible.
All right, I'll accept the plea. He has 14 days to pay, and just for the record, that's election occurred on May 9th of 2025. Okay, we're all set. Thank you, counsel. Who's your other one?
That would be Justin Glenn.
All right. Okay, and this is 251399, the People versus Justin Glenn.
Thank you, Your Honor. Dove Lustig on behalf of Mr. Glenn, and thanks for hearing this early. The prosecutor was able to pull the 230 file. I have the agency authority granted to me by him to offer 3 counts of responsible to defective equipment. I think that because they're civil, they're $260 each, and we can have that forwarded within 14 days. In exchange for those pleas, I believe Ms. Marino is going to dismiss all of the original other charges.
Yeah, so I have the misdemeanor file 1399 would be dismissed, and the A file, sorry, the hiccups. The A file and the F file would be dismissed if you pled to 3, let's see, unsecured load and 2 defective commercial vehicles. Did I say that all right?
You did. So if we look at the ticket on page 1 of 2, the red light's dismissed, the spilling load misdemeanors dismissed. There's a responsible to the 3rd one, which is unsecured load, correct? The 2 defective equipments are responsible, correct? And the no proof of insurance she's dismissing, I've showed her proof of that.
Yes.
Or represented
perfect.
proof of that. Yep.
All right, and so all 3 are alleged to have occurred on April 29th. It looks like the unsecured load is actually going to be amended to a defective equipment. So it's 3 defective equipments.
Yes. However you want to do that, that's fine with me.
All right, and how do you plead to those 3 allegations, 3 counts of defective commercial vehicle equipment violations?
Responsible, Your Honor.
All right, I'll accept the plea as knowing and voluntarily given on all 3 of those files, and your client has 14 days to pay. Each has a fine of $260.
Fantastic. Thank you. Have a great day.
All right, great. Thanks, you too.
Bye-bye.
Okay, this is 251295, the People versus Tyler Charlie.
Good morning, Honor. James Kazicki on behalf of Mr. Charlie. Waive reading of the complaint, stand mute. He's going to plead to fail to display.
All right, sir, can you turn your camera on and unmute? Mr. Charlie, I need you to turn your camera on and unmute.
Hello? Hello?
Hi, can you turn your camera on, sir?
I'm trying to figure out how to do this.
Okay. All right, there you are. Sir, can you tell me your first and last name?
My Tyler Charlie.
Sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes, ma'am.
Did you understand your rights?
Yes.
And did you give Mr. Kazicki, your attorney, permission to sign your name on that form?
Yes, ma'am.
All right. So it looks like, sir, you're being offered a plea, and you would plea, it would be reduced from a driving while license suspended down to a fail to display. That's a misdemeanor punishable by up to 90 days in jail and a fine of up to $100 plus court costs and statutory fees. You understand that, sir?
Yes, ma'am.
Okay, and you understand that if you enter a plea of guilty, you'll be waiving the trial rights listed on this form. There will be no trial of any kind. You understand that?
Yes, ma'am.
You understand that if you are currently on probation or parole, I don't know if you are or aren't, but if you are and you enter a plea, it could be a violation of your conditions. Do you understand that?
Yes, ma'am.
And you understand if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation.
Yes, ma'am.
Knowing all that, sir, how do you plead to the amended charge of failing to display a valid license?
I plead guilty.
Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No.
Are you pleading guilty of your own free will?
Yes, ma'am.
Sir, were you operating a motor vehicle in the city of Taylor on April 21st of 2025?
Yes, ma'am.
While you were operating that motor vehicle, did you get pulled over by a police officer for some sort of infraction?
Yes, ma'am.
Did the officer ask you to display a valid license?
Yes.
Did you fail to do so?
Yes, ma'am.
Okay, I'll accept the plea as knowing and voluntarily given. Are you satisfied, Mr. Kazicki?
Satisfied, Your Honor.
All right, I'll accept the plea as knowing and voluntarily given. Sir, you have $100 fine, $100 court cost, crime victims' rights fee is $75, and state assessment of $50. Those are both mandated by the state of Michigan. Your total is $325. You could pay that in 1 week.
Okay, thank you.
Okay, you're all set, sir.
Thank you.
Thank you, Your Honor.
Have a good day. Okay, and then I have the City of Taylor versus 2324578.
Good morning, Your Honor. Gregory Sheena on behalf of the respondent.
Okay, good morning, counsel. So I have a plea in front of me that's being offered to your client, that if your client pled on the E, F, and G files, all of which are, well, let's see, we have a defective equipment, no registration on a commercial vehicle on person, and another failed to maintain equipment. Looks like it'd be a defective equipment as well. The remaining 4 files would be dismissed. Is that your understanding as well?
That is, Your Honor, and I do have authority to enter a plea of responsible on behalf of the respondent.
All right, and all of those are alleged to have occurred on March 23rd of 2025. So I'll accept your plea on those. And Does your client need time to pay? Can they pay these in 14 days?
Yes, Your Honor. Thank you so much.
All right, pay in 14 days and the remaining files will be dismissed.
Have a wonderful day. Happy 4th of July to everybody.
Thank you, you too. Also, give me just 1 second. You're next.
First on my docket is Edwin Chavez Marino. Are you here, sir?
Primera persona está dentro de la sala, es Edwin Chávez Marino. ¿Se encuentra presente?
Sí.
Ya.
I will call your case then, and we will be on. Court security is not muted. We're on the record in 2025 TR 686, State of Kansas versus Edwin Orlando Chavez Marino.
Ok, vamos, asegúrese de que su micrófono no esté en silencio y ahora vamos a iniciar la grabación para el número de caso 2025 TR 686, el estado de Kansas contra Edwin Orlando Chávez Marino.
The state appears by County Attorney Jared Regier, and the defendant appears in person and pro se.
El estado está siendo representado por el abogado del condado, Jared Regier, y el acusado está presente.
Mr. Chavez, you are charged in count 1 with operating.
The loser.
Deputy Koffelt, court security is not muted. Thank you. In count 1, Mr. Chavez, you are charged with operating a motor vehicle without a valid license.
Gracias. El cargo número 1 que tiene el señor Chávez es de manejar un vehículo motorizado sin una licencia válida para conducir.
This is called a Class B misdemeanor, which means if you were to be convicted either by plea or sentence, the maximum penalty could be up to 6 months in jail and a $1,000 fine.
Esto es conocido como un delito menor de clasificación B y señor Chávez, si usted es encontrado culpable, ya sea por su propia declaración o por sentencia, la penalidad máxima podría ser de hasta 6 meses en la cárcel como máximo y una multa que puede ascender a los $1,000.
In count 2, you're charged with driving without the required ignition interlock device following a DUI.
En el cargo número 2, se le acusa de manejar sin el medidor interlock que debía utilizar.
This is called a Class A non-person misdemeanor, which means if you were to be convicted by plea or trial, your maximum penalty or sentence could be up to $2,500 in fines and 1 year in jail.
Y esto es un delito de menor de categoría A, y eso significa que si usted es declarado culpable, ya sea por su propia declaración o porque haya llevado su caso a juicio, entonces la penalidad máxima o sentencia podría ser de hasta $2,500 en multa y un máximo de hasta 1 año de cárcel.
Now, I've told you the worst possible thing that could happen in these charges, but typically we see fines and probation.
Yo le acabo de decir cuáles son los peores resultados posibles que podrían presentarse en este tipo de cargos, pero por lo general se ponen multas y se da libertad condicional.
Excuse me just a moment. Who is the lady with the automobile Motorola Moto G Stylus 5G 2020?
That's me,
What's your name?
Carly,
Carly's what?
Carly Wilson.
Carly Wilson. Miss
Yes, ma'am.
Wilson, your constant movement is a distraction. Could you
Apologize.
remain still? And don't be driving or having anyone drive you in that automobile.
Yes,
I don't know-
ma'am.
I don't know if the deputy told you, but nobody's to be in a moving automobile.
Yes, ma'am.
Thank you. Now, back on the record in Mr. Chavez's case.
Volvemos a la grabación para el caso de Chávez.
Mr. Chavez, you have the right to plead not guilty and set these charges for trial at a later date.
Señor Chávez, usted tiene el derecho de declararse inocente para llevar su caso a juicio en una fecha más adelante.
Or you can plead guilty, that is, admit the charge and proceed with your sentencing today.
Usted puede declararse culpable y al hacer eso usted estaría admitiendo los cargos y acusaciones y entonces se procedería a dictar la sentencia el día de hoy.
If you do not want to admit the charges, but you don't want to take them to trial, you can enter a no contest plea.
Si usted no desea admitir los cargos, pero tampoco quiere llevarlos a juicio, usted puede declarar que no va a disputar los cargos.
Even though you would not be admitting the charges with no contest, you'd still be found guilty and proceed with sentencing most likely.
Aunque usted no admita los cargos, declarando que no disputará los cargos, de todas maneras se puede dictar una sentencia de culpabilidad y procederíamos con la sentencia en caso de ser así.
Before you decide how you wish to plead, you do have the right to hire an attorney, and if you cannot afford to hire an attorney, you can apply to the court and see if you qualify for court appointed.
Y antes de que usted decida cómo desea declararse, usted tiene derecho a contratar un abogado y si usted no puede costearse los precios de un abogado, usted puede aplicar para que la corte le asigne un abogado.
You also have the right to waive counsel and represent yourself if you wish.
Y también usted puede renunciar a su derecho de contratar a un abogado y representarse a sí mismo, si así es como desea proceder.
Do you understand the right you have to an attorney?
¿Y usted está consciente de que tiene derecho a contratar a un abogado? Ya.
Including the right to apply for court appointed if you cannot afford an attorney. Do you understand that?
Y también está consciente de que puede aplicar para que la corte le asigne un abogado si usted no se puede costear el precio del mismo.
Sí.
Ya.
Do you want to have an attorney or do you wish to waive your right and proceed?
¿Usted quiere contratar a un abogado o quiere renunciar a ese derecho y proceder por su cuenta?
Yo voy a contratar un abogado por mi parte.
I will hire my own attorney.
All right, so you will be entering a not guilty plea then today,
Ok, entonces se declara inocente el día de hoy.
and I will set this for bench trial on August 20th.
Y entonces llevaremos esto a juicio en la fecha 20 de agosto.
You and your attorney need to be back here August 20th at 1:30 for trial.
Usted y su abogado deben de estar presentes aquí en la fecha 20 de agosto a las 1:30 para el juicio.
Now, the county attorney will be required to have witnesses ready at that time. So if you and your attorney decide you don't want a trial, let them know as soon as possible to give them time to cancel those witnesses.
El abogado del condado tiene como requisito el traer testigos. Y entonces, si usted y su abogado deciden que no quieren llevar ese caso a juicio, entonces, por favor, avísele al abogado del condado lo más pronto posible para darle tiempo suficiente para que cancele la presencia de los testigos.
In your honor,
Yes.
I do just want to make sure, do you want to put that on a bench trial date or an interpreter docket date?
Oh, thank you. I'm changing that date, sir, to August 6th at 1:30.
Voy a cambiar esa fecha para el día 6 de agosto a las 1:30.
You and your attorney must be here August 6th at 1:30, ready for trial.
Usted y su abogado tienen que estar presentes el día 6 de agosto a las 1:30 y estar listos para el juicio.
Okay.
Do you know who your attorney will be?
¿Usted ya sabe a qué abogado va a contratar?
Sí, va a ser Bill and Mitchell, LLC.
Yep, it'll be Bill and Mitchell, LLC.
Thank you. Now, one more thing, because you're appearing on a citation and the officers did not arrest you on the roadside, you must go into a breakout room at the conclusion of this hearing with court security too, and set up a time to get your pictures and prints taken.
Otra cosa más. Usted ya cuando acabe esta audiencia, usted tiene que ir a una sala por separado con el usuario Court Security 2 y entonces usted va a programar una fecha para que le tomen las fotos y las huellas digitales debido a que usted vino aquí bajo citación y los oficiales no lo arrestaron cuando estaba en el camino.
It is the order of the court that you keep the date and time they give you to get your picture and prints taken.
Y el mandato de la corte es que usted conserve la fecha y la hora que ellos le asignen para tomarse las fotos y las huellas digitales.
I do not intend for the officers to keep you. I intend for them to take your picture and your prints, have you sign a $5,000 bond. You will not have to put that money up unless you fail to come to court at future dates.
La intención no es que los oficiales lo tengan bajo custodia, lo retengan, simplemente tiene que tomarse las fotos, tiene que tomarse las huellas digitales y entonces tiene que firmar un papel donde se le pondrá una fianza de $5,000. Usted no tiene que pagar ese dinero a menos a que usted falte a las fechas que se le ponen en la corte.
Do you have any? Oh, and I also wanted to tell you, if for some reason you find out you cannot afford an attorney, come to the courthouse for an application to apply as soon as possible rather than waiting for your court date.
Y otra cosa también que le quería informar, si por algún motivo usted no puede costear los precios de un abogado propio, entonces venga a la corte lo más pronto posible para que usted complete la aplicación y entonces pueda tener un abogado asignado por la corte. Pero todo eso tiene que hacerlo antes de la fecha de la audiencia.
Do you have any questions before I let you go into the breakout room with the officer?
¿Y usted tiene alguna pregunta que usted quiera hacer antes de que lo enviemos a la sala por separado con el oficial?
Sí, la pregunta es ¿a dónde tengo que ir para tomar la foto y las huellas?
Yeah, the question is, where do I need to go to get the pictures and the fingerprints taken?
It will be at the Butler County Jail in El Dorado,
Eso será en la cárcel del condado de Butler, en El Dorado.
formerly called the Butler County Detention Facility.
Anteriormente se le conocía como centro de detenciones del condado de Butler.
And I know if you're out of state, that's a real inconvenience, and I apologize for that. But state law does require me to order it and for you to comply.
Y si usted está fuera del estado, ya es un conveniente y le pido disculpas por eso, pero la ley requiere que le dé este mandato y también requiere que usted cumpla y lo haga en ese lugar.
Any other questions?
¿Tiene alguna otra pregunta?
Y eso lo necesito hacer ahora mismo o lo puedo hacer una semana antes de la corte.
Do I need to get that done right now or can I do it 1 week before the court date?
Well, you'll need to do it when you set it up with the officer, what date he gives you.
Usted lo tiene que hacer en la fecha que le indique el oficial.
Okay.
Any other questions?
¿Alguna otra pregunta?
Yo no tengo que hacer nada, acá mismo me van a transferir con el abogado.
So I don't need to do anything. I will be transferred with the attorney.
You're going to be transferred with court security, the officer that will set up your time to come to the jail.
Usted será transferido con la seguridad de la corte. Eso es un oficial que va a programar su fecha y su hora para que usted venga a la cárcel y le tomen las fotos y las huellas.
So watch your screen for something to pop up that'll invite you to a breakout room. When you see that pop up, click on that and you should end up in a private room with the court security.
Ok, entonces usted tiene que estar pendiente a su pantalla porque le va a salir una opción o un aviso para ir a una sala privada. Cuando le llegue, usted la acepta y entonces usted va a ir a la sala privada para que hable con el oficial.
All right, so Michelle, if you'd please put Edwin Orlando Chavez Marino and court security and the interpreter in a breakout room. But before the interpreter goes, would you ask if anyone else needs an interpreter, please?
Ok, Michelle, por favor, coloque a Edwin Orlando Chávez Moreno y a la sala privada con el seguridad de la corte y también llévese al intérprete, pero antes de eso, por favor, pregunte si alguien más necesita un intérprete.
This hope just to come sit down.
I'm hearing someone. So is there anyone else that needs an interpreter, a language interpreter?
¿Alguien más necesita utilizar a un intérprete?
Deputy Coffelt, anyone down there with you that might need an interpreter?
No.
Alfonso de la Rosa Ramos, are you here?
Yes.
You sound like you don't need an interpreter.
No.
All right, well, thank you, Mr. Arambolo. If you wouldn't mind going with them in the breakout room.
You welcome, Your Honor. Just send me the invite and I'll be there.
Thank you.
Do you want court security
good day.
1 or court security 2 in the breakout room?
Court security 2.
Okay.
And Mr. Arambolo, the interpreter, and Mr. Chavez Marino. And Mr. De La Rosa Ramos, since I bothered you, why don't we go ahead and call your name up?
Okay.
Wait a minute. Are you an interpreter?
Me?
I thought I just saw something about interpreter behind your name.
Oh, no.
There's so many words out there on that screen that's they kind of blur. All right, so where are you, Mr. De La Rosa?
Where am I?
Yes, which one are you? Are you the one in the white t-shirt that says
Yes.
Samson?
Yeah.
Okay.
Yeah, I'm
Okay, so we'll be on the record now in 2025 TR 635, State of Kansas versus Alfonso de la Rosa Ramos. Jared Regier for the state, the defendant, Mr. De La Rosa, in person and pro se. Sir, you're charged with 1 count alleging that you were driving without a driver's license in Butler County. This is called a Class B non-person misdemeanor. If you were to be found guilty, the worst possible penalties could be up to $1,000 fine and 6 months in jail. Usually there's a much lower fine and probation, but you have the right to plead not guilty and set this for trial, or you can admit it by pleading guilty. Or if you don't want to admit or deny, but you don't want to go to trial, you can plead no contest. That means you don't admit it, you don't deny it, you basically stand mute legally on the issue, and you will still be found guilty and proceed with sentencing today. Now, you do have, as I told the gentleman before you, the right to an attorney. You can hire any attorney of your choice, and if you cannot afford to hire an attorney, you can apply and see if you qualify for court appointed, or you can waive your right to an attorney and represent yourself. Give me just one moment. There is another point. Do you want to hire an attorney, apply for court-appointed attorney, or represent yourself, sir?
No, represent myself. Declare I'm guilty.
Now, are you from Kansas?
Yeah, Kansas City, Kansas.
Okay. Well, looking at the cases filed in Kansas, the only one I'm seeing come up on the computer is this one. It may be that you would qualify for the county attorney's diversion program. Have you heard of diversion?
No.
It's a program where you go online and apply. There is a fee for applying. I don't know what it is, but if you're approved, you will pay your fine, your court costs, and another fee. And you'll have to show proof that you've gotten your driver's license, and they would dismiss the charges.
Yeah, but no, I do not have a driver license.
Well, do you think you could get one anytime in the near future?
Maybe because I'm on a case with a migration lawyer, but I'm not sure when it's gonna be happen. I'm like on. If that process gonna take like a while. But yeah, I'm not sure when, if it's like on this year or next year, but I'm waiting for a lawyer.
I understand those immigration cases take a long time. Well, you'd have to be able to get it in probably the very near future, within probably 6 months, I would think, but I don't know. But
No, I don't think it'll be in 6 months.
All right, so if you don't want to go to diversion, did you say you did want or did not want an attorney?
No, well, if I can pay like my fine on payments, yeah, I don't think I need an attorney. I just want to pay the fine.
If you're found guilty by plea or sentencing, by plea or trial, then I would give you a fine and most likely probation. And yes, I would give you time to pay. I typically do.
Okay.
So again, let's establish first of all that you understand your right to an attorney, and if you can't afford one, you understand your right to apply, and you understand that or not?
Yes.
Okay, and do you want to have an attorney or do you want to waive your right and represent yourself?
I represent myself.
Say that again, please. Carly Wilson just interrupted.
Yeah, no, just represent myself.
Okay. And is anyone making you waive your right to an attorney?
I'm sorry, what?
Is anyone forcing you to waive your right to an attorney or promising you anything?
No.
Then I will accept your waiver of counsel and have the record reflect that you've done this knowing what you were doing and voluntarily. And I'd have that in the journal.
That's my finding. Anyway. Yeah, we have some. Courthouse case of the people versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Your Honor, Joe Simon, on behalf of Mr. Treadway. Jacob, state your name when you get up here.
My name is Jacob Treadway, Your Honor.
All right.
Your Honor, for arraignment purposes, we waive formal reading and stand mute.
And then they will waive formal reading, standing mute. Court will enter not guilty plea.
And regarding the pretrial, we've reached a resolution.
We have, Your Honor, the resolution is on count 2, operating one designated character. Guilty guilty that at count 2, accept that guilty plea to count 1. In addition, there is a PBT refusal civil infraction case before this court. I think
you guys are going to need to do the plea form for me. Normally I wouldn't require it, but there are new requirements of the court rules, so that he has to acknowledge in writing. So I'll have you fill that out. It's going to be an additional dismissal of a citation. Needs to be noted on what's.
Your Honor, thank you. We'll do that, but I think Mr. Siller was just documenting what he's going to do in a different court. We're not doing.
In that case, not.
I understand.
Oh, okay. Okay. All right.
All right.
You need that number?
All right. I'll pass it. You can have a seat, sir.
Thank you, Your Honor.
Court calls case people versus Vincent Dunlap.
People.
I think Mr. Stiller's on some of the other cases, but
Conrad Silver on behalf of Pittsfield Township.
sorry, Mr. Stiller, handling much stuff. Good afternoon, or good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Dunlap on the cases ending in 0353 and 0354.
Good morning, Your Honor. The please this honorable court, Brandon Bird on behalf of Vincent Dunlap on the case ending in 0589.
All right. And what are we doing?
Oh, Your Honor, respectfully, got to speak with brother prosecutor and counsel over here, and we would like to plead all 3 cases to the civil infraction of a double parking.
That's correct, Your Honor.
Yeah, there's a state case that wasn't part of any resolution I was involved in negotiating.
I'm not a prosecutor. I'm a prosecutor for the EWS case.
That's why I thought I spoke with you earlier. Awkward.
Well, it looks like we do not have any.
Then, Your Honor, respectfully, can we adjourn this matter to see how his other felonies play out? I know his preliminary exam got pushed back Last time we adjourned it, to see what was gonna happen.
Do you want to adjourn yours out?
Please, Your Honor.
I have July 16th or August 6th, which is the preference if you're trying to time it up with an exam date.
July 16th, Your Honor.
July 6th. This being case 589, I'll adjourn that matter to July 16th, 2025, 9 a.m. Bond on that matter will continue.
My cases are the cases with Mr. Stiller, Your Honor, so I would, we are going
Double
to,
parking on both.
correct.
Double parking in each case, Your Honor. I'm gonna move that count two in each case, double parking. If you accept that admission fee in each case, then it's just the original charge in each case.
That's a correct statement.
That is, Your Honor, thank you.
Dunlap,
Yes.
in case ending in 353, do you admit responsibility to the fact that on April 2nd, 2021, Pittsfield Township, that you double parked a motor vehicle?
Yes.
On the case ending in 354, on the date of April 2nd, 2021, do you admit responsibility to the fact that you double parked a motor vehicle in Pittsfield Township?
Yes.
Court will accept those admissions in each case. Count two, count one is dismissed. In each case, fines and costs are $180, so that's a total amount of $360. Has to be paid 60 days. I'll make it 90 days after release.
Thank you, Your Honor.
Thank you.
All right.
Court does call the case of the people versus Juliet von Ocean Bear Martinez. This is Mr. Siller's case.
All right, so on behalf of Pittsfield Township.
All right. Ma'am, can you state your name, please?
Devin Julia Martinez.
All right. Pardon? Yes. Mr. Martinez, this is an arraignment on a misdemeanor complaint that alleges that on or about May 18th, 2025, at the location of Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan, that you were in possession of drug paraphernalia. Do you understand the nature of that charge, ma'am?
Yes.
That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
Right.
All right. And my first question to you is, do you want to be represented by an attorney?
It isn't
Pardon?
necessary. It isn't necessary.
Is it necessary?
It isn't necessary.
Well, it might be.
I said it isn't necessary, so could I just speak for myself?
Okay, what do you want to do on the case?
Just let me think.
Hey, Ms. Martinez?
Yeah.
Are you still, you had other cases a while back. Are you still on probation on those cases?
No.
Okay, so you're not before the court, a court on any other things?
I am. But none of them are drug related. And they're about to be finished.
Well, maybe. What other courts are you before, Ms. Martinez?
Is it necessary to expound upon this?
Pardon?
Is this relevant?
Well, it could be, because you could be facing additional sanctions depending on those cases, depending on what happens in this case.
Well, is there any way to live this down? Like have it like
To do what?
have it go like is there any way to like forget about this somehow? Is there anything that I can do like community service or something that I could do instead of
Ms. Martinez, you don't have, that's why I think you would need an attorney. I mean, you can proceed on your own if that's what you want to do. But quite frankly, me knowing a little bit about your history, I don't know that that would be a wise call on your part.
guess so. Like what like I suppose.
Ms. Martinez, just answer me this. Are you represented by the public defender's office on your other matters?
Yes.
Okay, don't you think it might be wise if they help advise you on this matter and also help you with those other matters? Doesn't that make sense to you?
In a way.
In a way. Okay, in a good way?
In a way that is like I can have this be adjourned with a bond. Can I know what the bond is?
Ms. Martinez, I don't even have a plea from you at this point.
Oh, please, I'm guilty.
No, I didn't mean that.
No.
So,
I'm not protesting to the allegations. I would like to
well,
just,
but hold on. I don't want you saying anything about the offense.
well, I do. I see no way around it. It's plain and clear and simple. and
Well,
there's-
I know that, and that's why people get attorneys, because sometimes they don't see any way around it.
But it's clear. It's plain. Like,
Oh, I don't know that, Ms. Martinez.
yeah, I guess I'll go with a lawyer, sure.
You will? Good. Okay, public defender case.
Assistant Public Defender Natalie Pate and on behalf of Ms. Martinez, Your Honor, we would waive any further reading. My client stands mute and ask that a not guilty plea be entered. I would ask, Your Honor, for an adjourned pretrial date. However, a more lengthier adjournment. The public defender does represent Ms. Martinez on her other matters. She actually has been referred to the Forensic Center and does have an appointment today with them.
Got
So
it.
I would ask for a lengthier adjournment to that end, Your Honor.
You should have led with that. All right.
The appointment is today?
When she has the appointment today?
It's scheduled for today per the letter from the center.
Got it. Do you know when the hearing date is set on the other matter?
Her latest court date in circuit court is July 28th and her bond is denied on that case. So
Got
I
it.
believe it's the 28th.
Okay, so what I will do is I'll adjourn this matter out to August 6, 2025, 9 a.m. I'll set the defendant's bond so that she's getting credit because she's being held on that other case. I'll set her bond at a $5,000, 10% bond on this case. Order standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. All right, thank you.
Thank you, Your Honor. Thank you, Ms.
Miss-
Martinez.
Miss,
I'll be
ma'am,
down.
It says on the forensic center is coming to see me today.
It's scheduled for today, but I'm not sure if maybe I don't have the most updated information. So there's a chance it might be rescheduled, but from what I can see, it looks like it was scheduled for today. But either way, we'll be in touch, Ms. Martinez, but you're all set for court here today.
What did you mean?
We're all set for court here today, Ms. Martinez, but I'll be down to see you before August.
Okay, but what is your name?
Oh, sorry, Natalie. I did not hear. I apologize, Natalie.
Natalie who? Natalie who?
Natalie Pate.
Pate. Thank you.
All right, thank you.
Thank you, Ms. Martinez.
Court does call the case, people versus Jacqueline Murray.
Kyle Brill on behalf of Ms. Murray. State your name for the record.
Jacqueline Murray.
All right, what are we doing?
And
The court should be in receipt of a plea form. The defendant is
I just need to-
pleading guilty
Can you
to
just
count
sign
one
that real
retail
quick?
fraud in the second degree. Count 2, 3 here are going to be dismissed as well as a case in district court.
and today is July 2nd, if you could. And Your Honor, I'm having Ms. Murray fill out the form right now, as well as
Fill out which?
the plea form.
July.
So no, I'm not in receipt.
Not in receipt yet, no, as well as the, just sign that, as well as the advice rights form. And if the court needs some help deciphering my handwriting, I'd be happy to provide it. But it's everything as Ms. Londy stated on the record, as well as an amount of restitution between the two cases for a total of $1,281.57.
I have that she's going to be pleading to a retail fraud second. The 1-year offense. Is that what this is supposed to say?
That's put the wrong time
All
there.
right.
Yeah, my apologies, Judge, that's the error.
And then, well, it's a 1-year offense.
Yes.
I get it, but then there is total amount of restitution. I see the 1281.57. And then that looks like it's off of 2 cases.
Yes, Judge,
This
that,
case and another case. And then it just says that the prosecutor and defense agree that they'll dismiss case 250021 in the 15th District Court.
Yes, Your Honor.
Have her sworn.
You solemnly swear and affirm the testimony about the whole truth and nothing but the truth. So help you God.
Yes,
State your name.
Jacqueline Murray.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the 2nd degree.
Yes, Your Honor.
All right, that's a misdemeanor punishable by up to 1 year incarceration and $2,000 fine plus court costs. The fine could be increased at 3 times the value of the fine to be taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, I did, Your Honor.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand that you're pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yep.
Yes?
Yes.
Are you on probation or parole?
What? Am I on?
yeah, are you currently on probation?
No. No, Your Honor.
Okay, let me try it again. I'll break it apart. Are you on probation?
No.
Are you on parole?
No.
All right. Has anybody promised you anything other
No.
than what's been stated here today on the record?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily
Yes.
and of your own free will,
Yes.
and also because you believe that you are indeed guilty of this offense?
Yes.
Between the dates of May 20th, 2019 and June 18th, 2019 at 3749 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan, what did you do at the Target?
Oh,
Makes you think that you're guilty?
I walked out with merchandise.
Okay, so you went into the store, you took merchandise and you walked out without paying for it?
Yes, Your Honor.
Was the store open to the public at the
Yes, Your
time? Did you have anybody's permission to take that property?
No, Your Honor.
And this property that you took, this was property that was offered for sale by Target?
Yes, Your Honor.
All right, is this on the value then?
Yes, Your Honor.
Was the total amount of property that you took from Target, was that in excess of $200?
Yes, Your Honor.
Counsel, have I complied with the court rule? I won't ask that. Ma'am, I do have to advise you that if I accept your plea and you commit some type of misconduct as defined by the Michigan court rules between the time I accept your plea and the time of sentencing, any type of sentencing agreement or evaluation of this case, the court is no longer bound by. You understand that?
Yes, Your Honor.
You also understand that because of that, if you also commit misconduct, you would not be entitled to withdraw your plea.
Yes, Your Honor.
All right, counsel, are you aware of any other inducements, promises, threats that have led to this plea?
No, Your Honor, and I will let the court know the defendant does have pending felony matters that are not a part of this agreement.
Yes, Judge, nothing else beyond what's been placed on the record. And, we did discuss the felony matters and we are aware that they're not part of this agreement.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
You are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
July 9, 2025 at 10 a.m.
July 9, 8. Okay, July 9, 2025. What time? 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
And we'll continue. Court calls case versus Nathan Bell.
Conrad Solar on the act.
Mr. Simmons.
Echelon people.
Cabral on behalf of Mr. Bell in both matters. So I was
here. No,
I don't believe so, Judge. Unless he's logged in on Zoom, I don't believe so, Your Honor. So I was just very recently appointed to this matter. I don't believe I have a good phone number for Mr. Bell. I'd ask at this time for either an adjournment or a show cause hearing to allow me time to send him a letter to hope to get in contact with him.
Bench warrant will issue bond 5,000, 10% each case. Those warrants will issue immediately. He's had previous warrants.
Judge.
Court does call the case people versus Daryl Frederick.
Conrad Solar on the act. Township.
Your name, sir? Daryl Frederick. All right. This is an arraignment. Sir, you are before the court on a new charge that alleges that on or about May 30th, 2025, at the location of Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that you were in possession of drug paraphernalia. You understand that charge, sir? Yes.
Yes, sir.
All right. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs, and any substance abuse counseling the court deems necessary. You understand that?
I do, Your Honor.
All right. First question that I have for you, sir, is do you wish to be represented by an attorney?
I do, Your Honor.
You do?
Sir.
Public defender, please.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Frederick, we would waive any further reading. My client stands mute and we would ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16th, 2025, 9 a.m. Bond in this case will be set in amount of, is this the only thing holding you or you're held by
No.
something else?
Oh, sorry, Your Honor. No, he's being held on other matters, several, and he has court dates on the 8th and the 9th of this month, but also the 30th. So I'd ask for a nominal bond in this case.
Bond will be set in the amount of $1,000, of 10% on that. Standard conditions including no assault behavior, no alcohol, recreational marijuana, or any illegal drugs. And I will put him on testing at community corrections 2 times per week. Placed.
Thank you, Your Honor.
Thank you. Court does call the case, recall the case, People versus Jacob Treadway.
Conrad Silver on behalf of Pittsfield Township.
Ready, Your Honor. Joe Simon on behalf of Mr. Treadway. Your Honor, they just informed me that Judge Fleischer wants me to come next door right now, but I know this court is higher importance. No,
I am.
Yeah, so let's get this done.
All right.
And so, Your Honor, I think maybe we should start again. For the purpose of arraignment, waive form reading and stand mute, pardon me.
Defendant in way formal reading, standing mute, court will enter a not guilty plea. I have before me a plea form that indicates that he is pleading to the charge of operating while visibly impaired and added count 2, the 93-day, $300 offense. Upon a successful plea to that charge, then count 1 would be dismissed, as well as a civil infraction. The file noted a PBT refusal would also be dismissed.
That is correct, Your Honor.
All accurate, Your Honor.
Raise your right hand. You solemnly sworn to affirm the testimony you're about to give be the truth, the whole truth, and so help you God.
Yes. My name is Jacob Treadway, Your Honor.
All right, sir, it is this court's understanding that you're pleading guilty to the charge of operating while visibly impaired. That is a misdemeanor punishable by up to 93 days jail, $300 fine plus court costs. The court could also order community service and any rehabilitative programs the court deems necessary. The court could also order your vehicle mobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes, Your Honor.
All right. And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights in that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plea?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
And because you believe that you're guilty of this offense?
Yeah, sorry, could you repeat that, Your Honor?
And you're doing this because you believe that you're guilty?
Yes, Your Honor.
April 18, 2025, at the location of State Street in Pittsfield Township, Washington County, State of Michigan, where you're operating a motor vehicle.
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, Your Honor.
What'd you have and how much?
I had about 8 to 10 beers. 3 of them were tall, Your Honor.
All right. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
You were taken to the station or the hospital?
I went to the station, then to the hospital, Your Honor.
All right. Was there a blood draw?
Yes, Your Honor.
And what were the results of that blood test?
It was 0.226, Your Honor.
Do you have any reason to dispute those blood test results?
No, Your Honor.
Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your consumption of alcohol?
Yes, Your Honor.
All right. Sir, I do have to advise you that if I do accept your plea and you commit misconduct as defined by the court rule between the time of my acceptance of the plea and the time of sentencing, any sentence evaluation or recommendation is withdrawn and the court is not bound by that. You understand that, sir?
Yes, Your Honor.
You also understand that if you do commit that misconduct as defined, that you would not be entitled to withdraw your plea.
Yes, Your Honor.
You understand that. Counsel, is counsel aware of any other promises, threats, or other inducements that have caused this plea?
No other promises, threats, or inducements.
No, Your Honor.
All right. And has the court complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
The court will accept the defendant's plea of guilty to count 2.
Your Honor, if it matters to setting the sentencing date, my client's been screened, assessed. He's commenced on farm recovery group. He is about three sessions completed of that 36-week program.
Well, I'll do my standard referral to Von Schwartz for an alcohol screening assessment. You can check with probation as to whether or not they want to do that, but I'll make that referral to Von Schwartz and the victims impact panel. Sentencing in this matter will be
July 30th, 2025.
July 30th, 2025, 12 p.m. Bond in this case will be set as a $25,000 personal recognizance bond, although under standard conditions, including no assault behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I am also ordering a community corrections order for testing on a SoberLink device at this time. All right,
Your Honor.
Anything further?
No.
No, Your Honor.
So, good.
Okay.
Appreciate it, man.
Yep. See you out there. Go ahead.
Bye.
Yes, but just wait for me outside.
Court calls case People versus Matthew Fonseca.
Sorry.
All right, so we have to do township.
Did you have some-
For the people.
I did have, but
They'll wait for me. They will wait for me. They'll wait for me.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Lewis Fonseca.
I think we're here for a pretrial and an arraignment.
Yes. As to the arraignment, sir, there's a complaint that alleges that on or about June 4th, 2025, at location of Washington Avenue near Hogback in Pittsfield Township, that you did have in your possession drug paraphernalia. You understand that, sir?
Yes, I do.
That's a misdemeanor, punishable by up to 90 days in jail, $500 fine plus court cost, and any substance abuse treatment the court deems necessary. Do you understand that?
Yes, I do.
First question I have for you on that is, do you wish to be represented by counsel?
Yes, I would like to.
This is a public defense.
We'll waive further reading, stand mute to the charges, and I'd request another pretrial date.
Defendant every way forward reading standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned to July 16th, 2025, 9 a.m. What are we doing on the other case?
I'd ask that it be set for the 16th as well. Mr. Fonseca has a felony that I've been in conversation with the people about. We're trying to do a global resolution.
All right. On the other matter, that being 751, I'll adjourn that to that same date of the 16th. As to his bond in the new case, I will set the defendant's bond at $5,000 personal recognizance bond under standard conditions, including no assaultive behavior or possession of any weapons. There's to be no alcohol, recreational marijuana, or any illegal drugs. I will also order that the defendant is to report to the Department of Community Corrections for drug testing. That'd be 2 times per week. And I'm sure, and I'll leave it there. I would. I'm sure you are going to apprise your client of proper attire when he comes into the court.
Thank you, Your Honor.
Thank you.
Thank you.
Court calls case People versus Kevin Gibson.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Devin Gibson, who is approaching. Please state your name for the record, sir.
Devin Gibson.
Thank you, Your Honor. I'm respectfully requesting an adjournment for two reasons. The one being that Mr. Gibson is being held on felony matters with his next court date being the 17th of this month. So I would ask for an adjournment after that date.
August 6, 2025.
Thank you, Your Honor. And the people did make an offer in this case Monday evening after I had met with Mr. Gibson that afternoon. I just still also need to discuss that with him. But thank you, Your Honor.
August 6th. Thank you. Court does call the case People versus Jermaine Nathan. 3 cases.
Conrad Silver on behalf of the township.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Nathan, who is approaching.
Right, Nathan.
Thank you.
Thank you, Your Honor. As to the two state cases that end in 0897 and then 0898, I would respectfully be requesting an adjournment into August for Mr. Nathan to get a Secretary of State appointment.
Does he have it set already or no?
No, not to my understanding yet, Your Honor.
Well, during those matters, August 6, 2025, 9 a.m. Bond continued in those cases.
And then, Your Honor, as to the case ending, the Pittsfield Township case ending 0060, Mr. Siller had made an offer to dismiss the misdemeanor and allow Mr. Nathan to plead to or admit to the civil infraction of double parking. And I discussed that with Mr. Nathan, and he would like to do that today in that case.
That is correct.
Mr. Nathan, do you admit responsibility to the fact that on or about January 7th, 2017, location in Pittsfield Township, specifically Washington Avenue, that you double parked a motor vehicle?
Yes, sir.
Court will accept that admission to count 2. Count 1 is dismissed, and this is in the case ending in 0060. Fines and cost of $180. When can you pay that?
Get it done by next month.
By next month? When next month?
What's the date today? The 2nd?
The 2nd.
2nd of next month. I'll pay
August, all right. Well, I'll make it August 4th. Okay?
Yes, sir.
Pay by August 4th, 2025. You're all set. Thank you. Court does call the case People versus Robin Muhammad.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Muhammad. Mr. Muhammad, please state your name.
Rahman Muhammad. Thank you.
We're asking for this for final settlement, please.
Jury final settlement conference will be set August 8th, 2025, 9 a.m. Jury selection will be set August 11th, 2025, 8:30. Both of those proceedings are in person. Bond will continue.
Thank you.
Court calls case of the People versus Jessica Fox.
For the people. Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Fox. Should be on Zoom, Your Honor. Yep.
Jessica Fox. I have a Jessica, but I have no idea if that's her. Ma'am, what's your name?
Jessica Lopez.
That's not her. Jessica Fox. There's no response.
Again, I did speak with her yesterday. We did have a resolution. However, we were going to adjourn due to some further conversations. I did expect her to be here. I don't have an explanation for her failure to appear.
Bench warrant will issue. Bond 5,000, 10%. That warrant will issue immediately. Court does call the case People versus Barrage Scott.
Conrad Silver on behalf of Pittsfield Township.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Barrage Scott, who is approaching. Please state your name for the record, sir.
We're eyes on the tape, Scott.
Okay.
Sure.
Can I talk to you?
What are we doing?
Your Honor, I'm moving to dismiss the case. Mr. Scott has completed a drug treatment program to my satisfaction.
Any objection?
No objection, Your Honor.
Case is dismissed.
Thank you, Your Honor.
Court does call the case People versus Eric. Is it Canis? Case Casey?
Pastor Lonnie for the people. Raise it, Your Honor.
Hello, Your Honor.
Hello, your name?
Eric James Casey.
Sir, you're here on an arraignment on two charges. The complaint alleges that on or about July 18, 2024, at the location of
this courthouse.
33.
Yeah, it all happened in this
Are you
courthouse.
going to interrupt
I'm
me?
sorry.
Are you going to let me continue with your arraignment?
Okay, I'm sorry, sir.
Which way you want to do it?
I'm not going to interrupt you.
Thank you. Complaint alleges that on or about July 18, 2024, at the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan, complaint alleges that you did make an assault and battery upon a Joseph Crossley. Do you understand the nature of that charge, sir? And I'm not asking you whether or not you did it. Do you understand what you were charged with?
Yes.
That is a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. This could be a consecutive sentence. And if a consecutive sentence can be imposed, if this did occur within a place of confinement, you understand the nature or the penalties in this case?
Yes.
You understand that?
Yes.
Count 2 on that complaint alleges that on that same date and at that same time, you did commit the offense of disorderly person jostling. You understand the nature of that, sir?
No, because I don't even know these people. The only person I know is
Do you
Joseph.
understand what you are charged with?
Well, I know what you're charging me with, sir, but
I am not charging you. Do you understand what you are charged with in count 2?
no.
All right, let me just do it formally then. July 18, 2024, the location of 4133 Washington Avenue in Pittsfield Township, Washington County, State of Michigan. Count 2 specifically alleges that on that same date and at that same location that you were a disorderly person. To wit, a person was found to be jostling or roughly crowding people unnecessarily in a public place at that location. Do you understand all of that?
I understand all that.
That is a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. Do you understand those penalties?
I understand this, Honor.
Do you wish to be represented by an attorney?
Yes, I guess so, Honor, because you didn't let me
Public
speak.
defender case.
Assistant Public Defender Natalie Pate on behalf of Mr. Casey, we would waive any further reading. My client stands mute and we would ask for an adjourned pre-trial date as well as a PR bond, please, Your Honor.
Defendant having waived for a reading, standing mute, court will enter a not guilty plea. Pre-trial in this matter will be adjourned to July 16, 2025 at 9 a.m. I will set the defendant's bond in this case amount of $5,000 personal recognizance bond. I will order standard conditions, including no assaultive behavior or possession of any weapons or anything fashioned to be a weapon. Do you understand that, sir?
Oh, yes.
Do you understand also that I am going to order no possession or consumption of any alcohol, recreational marijuana, or any illegal drug?
Yes.
I will also order that you are not to have any contact whatsoever with Joseph Crossley.
Don't want to. I'm sorry, sir.
You are really wearing on me.
I'm sorry, sir. I'm just trying to.
Do you understand the order? That was a question. Do you understand you are to have no contact with Joseph Crossley?
Yes. I haven't had no. I'm sorry.
It's one more time.
I'm sorry.
I'm changing the bond.
I'm sorry.
Is there any other requests of conditions from the people?
There is a request for a no go to, Your Honor, an address. May I give that to the court?
No go to, yes, go ahead.
10245 Talladay Road, Talladay in Willis, Michigan. 48191. That'd be good.
Any objection to that, counsel?
No, Your Honor.
All right, I'm going to order that there is no go to that location of 1025 Talladay Road, Willis. Thank you.
Thank you.
Thank you.
Sorry, Judge.
We may be off because they brought him out. You got Rayburn? I was just asking. Court calls case People versus Todd Rayburn.
Conrad Silver on behalf of Vincent Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Rayberg, who is approaching. Mr. Rayberg, please state your name.
Todd Rayburn. Thank you.
Your Honor, we're asking for adjournments on both cases. Mr. Rayberg is going to be released to treatment, hopefully. We're just coordinating all the cases to make sure that happens. So, and treatment is related to the resolution to these cases or this
Okay,
case.
you
So,
want an August date or a July date?
Maybe let's keep it on the 16th and just see what happens if that's okay with the court.
July 16, 2025, 9 a.m. Bond will continue in each of these cases.
Thank you.
Thank you. Let's call the case People versus Grant Ducia.
People.
Grant Ducia, no response, issue in order to show cause. Court does call the case People versus John Farrow. John Farrow. There's no response. I'll just add these to his additional like 13 other ones.
Yes, Your Honor.
Bench warrant will issue bond 5,000. Give a 10% privilege on it. Warrant will issue immediately. Court calls case People versus DeMar Ficklin.
People.
Hello.
My name is DeMar Ficklin.
All right. Sir, this is an arraignment. You are before the court on a complaint that alleges that between the dates of October 4, 2024 and October 18, 2024, at the location of 3825 Carpenter Road, Pittsfield Township, Washington County, State of Michigan, that being the Myers store, that you as an agent or trustee of that store did embezzle funds greater than or less than $200. You understand that charge, sir?
Yes.
All right. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become your maximum fine. You understand that? Yes. Okay. First question I have for you: do you wish to be represented by an attorney?
Yes.
See how easy that can be?
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Ficklin. We waive further reading, stand mute, and ask for another pretrial date, Your Honor.
Defendant every way for reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be adjourned July 16, 2025, 9 a.m. Set his bond at a $5,000 personal recognizance bond. All under standard conditions, including no assault to behavior or possession of any weapons. I'll also order that there's to be no alcohol, no recreational marijuana or any illegal drug. You understand that? Yes. All right. I will also indicate that the defendant is not to go to the 3825. Well, actually, I'm going to order he's not to go to any Meyer in the state of Michigan. You understand that, sir?
Yes.
All right. Anything else?
No, Your Honor, thank you.
Nothing, thank you.
Who's here with you? Who's that?
My mom.
Mom? So after that last gentleman came up and your mom knew you were coming up for arraignment, did she tell you how to act?
Yeah.
She did? And she probably said, don't do that?
Oh, yeah, yeah, yeah.
You got a wise mom. All right, thank you. Thank you, ma'am. Court calls the case, People versus Shania Williams.
Conrad Silver on behalf of Pittsburgh Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams, Miss Williams, excuse me. Please state your name for the record.
Shania Williams.
All right.
Your Honor, Miss Williams is being held on 2 other matters. She believes she may be getting out of custody on July 8th. So we're asking to set this
That's
case.
a hope and a prayer, or she knows?
Well,
Never
we're
mind.
not on that case, so I don't, it's a conflict case. So I'm just asking to set it after that. She's really wants to get her license back. And so if she's released, she'll work on that immediately.
July 16, 2025, 9 a.m.
Thank you.
All right, thank you. Court calls case People versus Cody Mahan.
Oh, really?
Cody Mahan. it's one of yours.
Echelon of people.
Hi, Burdell, on behalf of, but not with, Mr. Mahan. Lessons on Zoom.
Ian Zoom.
So, Your Honor, today is the date and time set for pretrial. I was very recently appointed to this matter. I don't believe I have good contact information for Mr. Mahan. So we are asking at this time for an adjournment or a show cause hearing to allow me to send him a letter or try to otherwise get in contact.
And warrant will issue bond 5,000. You have 10% privilege, that warrant will issue.
Thank you, Judge.
Court calls case People versus Tony Gomez.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Gomez. Mr. Gomez.
Good morning, Judge. Tony Gomez present. One moment, please, and I'll turn my camera on.
Thank you. Oh, where are you? There he is. Okay, gotcha. You're not driving, are you?
Negative, Judge. I just pulled over on the side of the road. That's why I wanted to take a moment.
All right, thank you. All right, what are we doing?
Your Honor, I am asking for an adjournment. I think the 16th date would be okay if that's okay with the people in your honor. Ms. Lonnie's looking into if there's CCTV footage from this incident.
Got it. I'll adjourn the matter to July 16th, 2025, 9 a.m. Or as your invite indicates, bond will continue.
Thank you, Your Honor.
All right, thank you, Mr. Gomez.
Thank you.
Court does call the case of the People versus Lamar Hampton.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hampton. Mr. Hampton, please state your name.
Mr. Hampton, Lamar Hampton.
All right, I need a camera.
Okay, I'm fixing right now. Can you see me
I
now?
got it. We got you.
All right.
A big old chain around your neck. Go ahead.
Your Honor, I am asking for an adjournment. I did speak with Ms. Lonnie about a resolution, but I was unable to reach Mr. Hampton about that resolution. So I just want to discuss that with him, please.
August 6th, 2025, 9 a.m. Or as your invite indicates, bond will continue. All right. Thank you, Mr. Hampton. Court calls case People versus Destin Hopkins.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Hopkins.
Oh, there he is. State your name, sir.
Destin Hopkins.
Thank you.
Your Honor, Ms. Pate spoke with Mr. Hopkins. She is asking for an adjournment until after July 29th. Mr. Hopkins has a sentencing on a VOP in circuit court. I think she wants to know what's happening there.
August 6th, 2025, 9 a.m. Bond continued. Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Khalid Ishar.
Oh, Echelon for the people. I'm sorry, I had Issa as the last name. I apologize.
Oh, it is. It actually is. I don't know what they Bashar Isa. All right.
Good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Isa or Hishar Isa.
Isa.
Yes, Your Honor.
Oh, hello.
Hello,
Hello, what's your name?
Bashar Isa.
All right, I need a camera. Oh, there you are. Okay. All right. I've got him now.
Thank you, Your Honor. Sorry about that. I was in the hallway. Assistant Public Defender Natalie Pate with and on behalf of Mr. Isa, who is present here via Zoom. I have discussed this matter with my client, and we are respectfully requesting to set this case for final settlement conference.
Jury final settlement conference will be set August 8th, 2025 at 9 a.m. Jury selection, if necessary, August 11th, 2025 at 8:30. Both of those proceedings are in person. All right. Thank you, sir. Bond continue.
Thank you, Your Honor. Thank you, Mr. Isa. You're all set for today, but we'll be in touch.
Court calls the case People versus Sophia Banco.
Assistant Public Defender Natalie Pate with and on behalf of
Sophia.
Mr. Banco is present via Zoom and has stated her name. Your Honor, I have discussed this matter with my client and briefly with the people. I'm requesting an adjournment of at least 3 to 4 weeks for a referral.
During the matter, August 6th, 2025, 9 a.m. Bond with its conditions will continue. All right. Thank you, ma'am.
Thank you, Your Honor. Thank you, Ms. Sabanco. You're all set for today.
Court calls the case People versus Jessica Lopez.
Good morning, Assistant Public Defender Lauren Perning on behalf of Ms. Lopez. Ms. Lopez, will you please state your name for the record?
Yes, Jessica Lopez.
Thank you.
Your Honor, we do have a resolution. Ms. Lopez will be pleading guilty of charge under a prosecutor's deferred.
That's correct, Your Honor. There are no other agreements.
Um,
Do you need that?
Oh,
I
right.
apologize.
I do because counsel approach so that you know why I have to do it this way. Because everybody wants to make judges' lives difficult. All right, we're back on the record in the Lopez matter. Ms. Lopez, what I'm going to do is I'm going to adjourn this out to July 16th, 2025, 9 a.m. Your counsel will explain why. It's no harm to you in that, but I'm going to put it out to that date. Okay, ma'am?
Okay,
Just a paperwork issue, Ms. Lopez.
all right,
The offer will be open at the next hearing.
All right. Thank you, ma'am.
okay, bye.
Court does call the case People versus Chad Maurer.
Good morning, Assistant Public Defender Lauren Perning on behalf of Mr. Maurer. Mr. Maurer, please state your name.
Yeah, you're not going to do that.
Well, Your Honor.
Unless it comes from on high, but not in Zoom.
I did speak with him this week, and last week. He tried to join the Zoom yesterday. He was texting me, calling me that he couldn't get in. So I know his intention was to be here, but I don't have an explanation for his actually here.
Bench warrant will issue for defendant's failure to appear. Bond $5,000, give 10% privilege. I will, however, not issue that warrant till the 7th. Okay. You're welcome. Court does call the case People versus Kenneth Miller.
Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. Miller. Mr. Miller, please state your name for the record.
Kenneth Miller.
All right, thank you, sir.
Your Honor, we are requesting adjournment for potential mitigation information to Ms. Londy. I would ask maybe for a little bit further than the 16th if possible. Mr. Miller is engaged in treatment.
Got it. Adjourn this to August 6th, 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, may
Yes,
I
sir.
ask a question? I was wondering if it would be possible to switch to the sober link from the tether. Because it's impeding me from being able to let my kids go to the pool because I can't get in to save them if they're gonna drown.
Wow. I'd have to hear that by motion or if it's arranged by stipulation of people. But sir, the alleged BAC in this matter is a 0.21 and there was a crash. So it's unlikely that I will be changing that.
I'll also note for the record, Your Honor, there was a 6-year-old in the car.
Yes. All right.
I'll speak to my client further about it, Your Honor. Thank you.
Thank you.
Thank you.
Court does call the case People versus Marcus Moore Jones.
Special money for people.
Excuse me, Your Honor. An Assistant Public Defender Natalie Pate with and on behalf of Mr. Moore Jones, who is present today via Zoom. Sir, can you please state your name for the court?
Marcus Moore Jones.
All right.
Thank you, Your Honor. There was an offer made in this case for my client to admit to the civil infraction of no proof of insurance, and in exchange, the misdemeanor charge would be dismissed. I did discuss that with my client, and that is what he would like to do today.
And that is a correct and complete recitation of the agreement. Does the court need that reduced to writing or?
No, it's a civil.
Thank you, Your Honor.
All right. Is that 155? 155.
Yes. Yeah, 257-328 is that fact code, Your Honor. Thank you.
All right. And Mr. Moore Jones, do you admit responsibility to the fact that on April 29, 2025, at US 23 in Pittsfield Township, Washington County, State of Michigan, that upon lawful request of an officer, you are unable to produce proof of insurance?
Yes, Your Honor.
All right, court will accept that admission to count 2. Count 1 is dismissed. Fines and costs of $155. When can you get that paid?
Can I do the beginning of next month?
Beginning of August?
Yes, Your Honor.
If I make it August 1st, will you be able to pay it?
Yes.
August 4th. I don't believe it, but you have it on the 1st. All right.
Thank you, Your Honor.
All right. You take care.
Thank you, Your Honor. Thank you, Marcus. You're all set for today.
Okay.
Court calls the case People versus Ashley Garcia.
People. Show cause.
On a failure to, she's here. Hello.
Here.
What's
Ashley
your,
Garcia.
all right. Ma'am, you are before the court on a misdemeanor complaint or citation that alleges that on or about April 23rd, 2025, at the location of South State Road in Pittsfield Township, Washington County, State of Michigan, that you operated a motor vehicle without proper security.
Yes, I didn't.
That is,
sure.
hold on. You understand the nature of that charge?
I do.
All right. That's a misdemeanor punishable by a fine for up to 1 year incarceration. Fine not less than $200 nor more than $500 plus court costs. You understand that?
I do.
First question I have for you is, you want to be represented by an attorney?
I don't think so.
Pardon?
I don't think so.
You know what you're going to do?
Pay the ticket? I don't know. No, I don't know.
Really?
I don't know.
You don't know? Do you think an attorney could help you with that?
I mean, sure.
You think an attorney could?
They could help, yeah.
They can help?
Yes.
So I'll ask the question again. Do you want to be represented by an attorney? Yes, great. Okay. PD case.
Sorry.
Thank you, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Ms. Castillo, we would waive any further reading. My client stands mute and we would ask for an adjourned pretrial date, please.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. I'll set a pretrial in this matter. Might be
Plus court costs and statutory fees. You understand that?
Yes, Your Honor.
All right. Mr. Fanto, the bonds were posted by a third party. So Mr. Kradiak, these bonds weren't posted in your name. Someone else posted them on your behalf. So if those bonds are to be, if they're to be applied, they're gonna need to come up to the courtroom so that those funds can be released.
Okay.
And if not, you'll need to make payment on it. You understand?
Yes, ma'am.
All right, sir, did you go over your constitutional rights with your attorney that are outlined on this advice of rights form?
Yes.
Did you understand your rights?
Yes.
And did you give your attorney permission to sign your name on this form?
Yes.
Sir, you understand that if you enter a plea of guilty, you'll be waiving the trial rights listed on that form. There will be no trial of any kind.
Yes, ma'am.
Okay. And you understand if you're currently on probation or parole and you enter a plea of guilty, it could be a violation of your conditions.
Yes, ma'am.
Okay. And if you're not a citizen of the United States and you enter a plea of guilty, it could have immigration consequences up to deportation. Do you understand that?
Yes.
Knowing all of that, Mr. Kradiak, how do you plead to the amended charge of failing to display a valid license?
Guilty.
Has anyone forced you to get you to plea?
No, ma'am.
Has anyone promised you anything other than the plea agreement to get you to plea?
No, ma'am.
Are you pleading guilty of your own free will?
Yes.
Sir, were you operating a motor vehicle in the city of Taylor back on April 4th of 2025?
Yes.
All right, did you get stopped by police officers for some sort of driving infraction?
Yes.
And when you get stopped, did the officer ask you to display a valid license?
Yes.
Did you fail to do so?
Yes.
Satisfied counsel?
I am, Judge. Thank you.
All right, I'll accept the plea as knowing and voluntarily given. Sir, you have a fine of 100, court costs of 100, crime victims' rights fee of 75, and state assessment of 50. That brings your total to $325. And I'll make a note on the, do you believe that this third-party person is going to release those funds to pay your fines and costs?
Yeah, it's my money. I just couldn't because I was in Wayne County.
Gotcha. Okay.
If we could just note pay within 30 days, Judge, and cover both sides.
Yeah, I'm gonna write third party will contact to release bonds. If not, payment within 30 days.
Okay.
Okay?
Thank you, Judge.
All right, we're all set. Thank you.
All right. Thank you too.
Okay. Then I have People versus Stone Transport.
Ready, Your Honor. Michael Levitt, I represent Stone Transport.
All right, good morning, Mr. Levitt. I have a plea form in front of me from the prosecutor that indicates if your client pleads on the overweight commercial vehicle file with a stipulated fine of $1,200, the remaining two files will be dismissed per plea. Is that correct?
That is correct, Your Honor. I do have full authority on behalf of my client to enter a plea of responsibility to that offense.
Okay, and I have that it occurred on May sixth of 2025. I'll accept the plea. Total amount due is $1,200. Your client has 30 days to pay, and the remaining 2 civil infractions are dismissed.
Thank you, Your Honor.
Thank you, counsel. All right, now I have the People versus Krosky Transport LLC.
Michael Levitt, I appeal on behalf of Krosky Transportation LLC.
Okay, I have another plea form here that if your client pled to the I file, the defective equipment and the overweight file, let me find that one. And the overweight file, which is the A file with an agreed upon fine of $2,000. Both alleged to have occurred on 4/29 of 2025. The files B through H would be dismissed. Is that correct?
It is correct, Your Honor, and I do have full authority on behalf of my client to plead responsible to those 2 offenses.
Okay, then I'll accept your plea on those 2 offenses. Your client has 30 days to pay, so total is $2,260.
Thank you, Your Honor. Have a good morning.
You too, thank you. Okay, now I have 251289, the People versus, is it Taman Hussein?
Good morning, Your Honor. Jeffrey Fant on behalf of Mr. Hossein. Excuse me, waive formal reading, stand mute. The no ops is being dismissed. He had a valid operator's license at the stop. And he'll plead responsible to the amended double parking, and he'll pay that within 2 weeks.
All right, you understand all of that, sir?
Yes.
All right, so the misdemeanor file against you is being dismissed, and the speeding tickets being reduced down to a double parking. Double parking is a 0-point ticket with a fine of $165. How do you plead to double parking on April 19th of 25? Responsible or not responsible?
Responsible.
All right, I'll accept that plea as knowing and voluntarily given. You have a fine of $165, 2 weeks to pay, and the misdemeanor file is dismissed.
Thank you, Judge.
Thank you.
All right, thank you.
You're all set, Mr. Hossein.
Thank you.
Okay, now I have the People versus Badur Transport Incorporated.
Good morning, Your Honor. Alex Dillon on behalf of Badur Transport.
All right, good morning, counsel. I have a plea agreement from the prosecutor that indicates if your client pled responsible on the C file for defective equipment with a fine of $260 alleged to have occurred on May 7th of 2025, the other 2 tickets would be dismissed for the plea, correct?
That's correct.
How do you have authority to enter into that on behalf of your client?
Yes, I do.
And how do you plea on your client's behalf?
Responsible.
All right, I'll accept that. It's a fine of $260. Your client has 14 days to pay.
14. Okay. Thank you, Judge. Appreciate it.
All right. Yep, we're all set. Thank you. Strickland, I'm sorry. Can you turn your camera on?
Yes, ma'am. I'm sorry. There you go.
All right, there we go. This is 251467 and 251468, the People versus Carter Allen Strickland.
Senator James Gazicki on behalf of Mr. Strickland. Waive reading of the complaint, stand mute. Request this matter be set for a settlement conference. There's also an order for discovery, Your Honor.
Okay, Serge, go over your constitutional rights with your attorney that are outlined on this advice of rights form.
Yes, I did, Your Honor.
Did you understand your rights?
Yes, I do, Your Honor.
All right, and did you give Mr. Gazicki, your attorney, permission to sign your name on that form?
I'm sorry, ma'am, you kind of lagged a little bit.
Sorry. Okay, did you give your attorney permission to sign your name on that form?
Yes, I did, ma'am, Your Honor.
Oh, okay. So I've signed the order granting discovery, and I've entered a not guilty plea for purposes of arraignment. And we will set this for a settlement conference with the complaining witness to appear. And we will allow this hearing to be via Zoom, since you live out of state, sir.
Thank you very much, Your Honor.
All right, we're all set for today.
I was just, when will I have the date of that next one?
You'll receive notice of it in the mail.
Okay,
It'll
thank you.
probably be 3 to 4 weeks out.
Okay, thank you very much, ma'am.
Yep, you're all set.
I'm sorry, I'm kind of new to the Zoom. Do I just sign out now?
Yeah, you're all set. You can sign out. We're all kind of new to it, even if we've been doing it for years.
Okay,
We'll
thank you.
help you.
Okay,
Yeah.
thank you very much.
All right, thank you. This is 251298 OT, the People versus Nesreen Saad.
Good morning, Your Honor. Rami Hijazi, P82830 on behalf of Nisreen Saad. Your Honor, in this case, my client is having a hard time logging in because she is in Lebanon, but we have resolved this matter and they are not moving forward with the misdemeanor charge anymore. It's just going to be a civil infraction of double parking. Would you be okay if I waive her presence? I have gone through all of her rights with her and I do have her signature as well on that.
Yeah, if you have authority, it's just a civil infraction, so the misdemeanor is being dismissed. And then the speeding is being reduced down to a double parking, a 0-point ticket with the fine of $165. And you indicated you had authority to enter into that on behalf of your client counsel.
Yes, Your Honor. We just request 2 weeks to pay if that's okay. And I do have full authority.
All right, and you plead responsible?
Responsible.
All right, I'll accept the plea. Your client has 2 weeks to pay. It's a fine of $165.
Thank you, Your Honor. I appreciate you.
Thank you. All right, now I have 25TA11071, the People versus Malak Beydoun.
Good morning, Your Honor.
Hi, good morning, counsel. Can I get your appearance?
Sure, Mohammed Sewa, P83365 on behalf of Malak Beydoun.
All right, I have a plea form in front of me that the ticket would be reduced down to a double parking. It's a 0-point ticket with the fine of $165. Do you have authority to enter into that on behalf of your client?
I do, Your Honor.
And it's alleged to have occurred on May 1st, 25. How do you plea on their behalf?
Responsible.
All right, I'll accept the plea. Your client has 2 weeks to pay.
Thank you so much. Have a great day.
Yep, you too. Thank you.
Bye.
Can I see one? Profile with a stipulated fine of $3,700. All remaining tickets would be dismissed, B through H. Is that your understanding?
That is correct. And I do have authority to accept that plea on behalf of my client.
Okay, to the allegation on 422 and 25, your client had an overweight commercial vehicle in the city of Taylor. How do you plead?
Responsible.
All right, I'll accept that plea. There's a fine of $3,700. Your client has 30 days to pay and all remaining files will be dismissed.
Thank you, Your Honor.
All right, thank you. Counsel Hampton.
Yes, Your Honor.
Hi, good morning. Have you met with the prosecutor already?
I haven't, Judge. I was put in a breakout room, but I didn't know if it was the wrong one because no one ever showed up.
We have a really heavy docket today, so Miss Marino might not have gotten to you yet.
Well, Your Honor, I was dealing with Miss Foster Tucker, and I was going to go in and speak to Mr. Houston, but he wasn't in there.
No problem,
All
Judge.
right. Yep, we'll put you back in so you two can talk.
Okay.
Thank you. April 25th of 2025.
Yes, ma'am.
And were you in the city of Taylor on that day?
Yes, ma'am.
And sir, was your license invalid either because it was suspended, revoked, or denied?
Yes, ma'am.
And did you allow yourself to operate that motor vehicle?
Yes, ma'am.
Are you satisfied with the factual basis, counsel?
Satisfied, Your Honor.
Okay, I'm going to accept the plea as knowing and voluntarily given. On that, you have $100 fine, $100 court costs, crime victims' rights fee is $75, and a state assessment of $50. Those last two are mandated by the state of Michigan, and that brings your total to $325. Now, you also have a speeding ticket, and it's being reduced down to a double parking. And double parking is a 0-point ticket, and it has a fine of $165. To double parking, how do you plead? Responsible or not responsible?
Responsible.
All right, I'll accept that plea as well. And that brings your total to $490. Mr. Hampton, does your client need a payment plan?
Yes, Your Honor.
2 months.
What? Do you think you can pay that all in 2 months?
Yes, ma'am.
All right, I'm gonna say pay in full in 90 days.
Thank you so much, Judge.
And just
Thank
in
you.
case anything happens. And Mr. Eaton and counsel, we have a pretty progressive payment plan program here. If he's going to be late on a payment or he doesn't have the full amount at the end of that 90 days, make sure he calls the court, or Mr. Hampton, you call, and we'll give him more time and he doesn't end up being show caused, okay?
Knowing Mr. Eaton, Judge, he'll probably call you every day.
All right. All right, well, we're all set. Everyone have a good day.
Thank you, Your Honor.
Thank you.
And Mr.
Thank
Eaton,
you,
you can
guys.
hang up. Thank you.
Yes, ma'am.
Good seeing you.
Yes, ma'am.
Thank you.
is how do you plead to driving without a valid driver's license?
Guilty.
By guilty, you're admitting the charge that you did drive on March 24th, 2025 in Butler County, Kansas without a driver's license?
Yes.
And according to the officer's citation or ticket, you're on the Kansas Turnpike, also known as I-35 Highway, near mile marker 90 north. Would you agree with that to put you inside of Butler County?
Yeah, I was coming to Kansas from Pratt County.
And then you got stopped in Butler County, it sounds like?
Yeah.
Okay, because that mile marker is in our county. All right, well, I will find that I do have jurisdiction. And you said you were driving an automobile at that location on that date of March 24th, 2025?
Yep.
And you did not have a valid driver's license?
No.
And I will accept your plea. Again, though, is anyone making you enter this plea of guilty?
No.
By any threats? Nope, no promises?
No.
And you understand you have a right to trial, but you're giving that up with this plea?
Yes.
Okay. I accept your plea as knowingly and voluntarily given. I find you guilty of driving without a license. Does the state have any recommendations before I pronounce sentence?
No.
Well, let's check with Mr. Gear, who represents the state of Kansas, and see if he does.
$100 fine, court costs, 120 days suspended jail sentence, subject to 6 months of non-reporting probation. This is a defendant who seemingly appears pursuant to the notice to appear date on the ticket. The state's information is that the statutory requirements of KSA 21-2501 subsection B appear to be outstanding, as I am not aware of any appearance bonds in this case, and the state will defer to the court on any issues concerning repayment of the case.
All right. Well, Mr. Ramos, I am going to follow those recommendations, which means your sentence is the following: a $100 fine and $108 in court costs, for a total due of $208. Now, you said you need some time to pay that. How much time will you need?
Just like a couple weeks and I'll pay the whole thing.
Would 30 days be enough?
Yeah, 30 days, it should be
All right.
enough.
All right, you get that paid within 30 days. And do you have your pencil there?
Yeah, I got a pencil.
To find out how to pay that online or through the mail or in person, please call the Butler County District Court clerk. The clerk's number is 316-322.
Okay.
4370.
Oh yeah, I think I got the info on my ticket.
Yes, you do. Okay.
Yeah.
So call her and she can tell you how to get that paid within 30 days. I'm also giving you a 120-day jail sentence, but I am suspending that, meaning you won't have to serve that as long as you are successful in completing a 6-month non-reporting probation. You won't have to report to probation, but you're still on probation, and you have 3 conditions. The first condition is violate no laws during the next 6 months. The second is pay your fines and costs within 30 days. And then the third condition, and this is very important, is that you go into that, if you haven't had your picture and prints taken, and I don't see that they arrested you, then you need to set up a time to get that done. And you do have to come back to the Butler County Detention Facility to do it. They won't keep you, but under Kansas law, since they didn't arrest you at the site, you have to come in and get your picture and prints taken. And if you don't, that would be a violation of your probation. If you're found in violation of your probation, you can serve that 120 days in the Butler County Jail.
Okay.
So where is court security 2? Are they still in with the other gentleman?
Yeah, he'll need to go into court security too. Judge, I don't have any kind of paperwork on him. What's the case number on this?
2025 TR 635, and it's under De La Rosa Ramos, under the D's. Alfonso De La Rosa, no driver's license, and he doesn't have to set a bond because he's already been sentenced, of course.
Okay, sounds good. Thanks.
So do you have any questions, Mr. De La Rosa, before you go into the breakout room with the officer?
No.
Okay, then, Mr. McGear, is there anything further we need to address?
Not from the state, Your Honor.
Thank you. Then, please, Mr. De La Rosa, look for that invitation on your screen. When it comes on, click on it and set up a date and time for condition number 3 of your probation.
Okay.
Thank you. We'll be in recess. We'll be on the record in 2025 TR 683, State of Kansas versus Gustavo David Polanco Samprun, Jared Regier for the state. Defendant fails to appear. I believe I found a journal entry by the state dismissing this without prejudice on July 1st. Is that what you show, Mr. Regier?
Your Honor, the state's information, this and new information has been brought to the state's attention regarding this case. The motion before the court is that this case should be dismissed without prejudice.
That is granted. We will now be on the record in 2025 TR 667, State of Kansas versus Justin Bruce Wolken. Jared Regier for the state. I understand the defendant fails to appear, and the methods have been taken to try to locate him. Mr. Regier, is there anything else we need to do on this case?
Forgive me, Your Honor. Could the state would respectfully inquire as to the case number?
It is 2025 TR 667. Looks like you tried to do an alias summons, but you were unsuccessful.
Your Honor, this is a case where a summons was previously issued by my office. I'm showing a return indicating negative service was filed with the court on April 15th of this year. Based off of that, my office did file a certain request for the court. I do not know the status of the same, but at this juncture, if the court is satisfied, the state respectfully suggests this case should be taken off docket pending further proceedings.
This case is taken off the docket pursuant to last filings entered. Will now be on the record in 2025 TR 696, State of Kansas versus Jesse Miguel Ibarra. Jared Regier for the state. Mr. Ibarra, looks like, I don't think he's here. Looks like you had some service issues with him. There was a document that said personal service on 4/4/25. However, that document was filed 4/2, 2 days earlier. And I saw a notation that thought perhaps that was an error, that you don't have service. Mr.
One
Regier?
moment, Your Honor.
Sure.
Your Honor, perhaps the court is aware of something that I am not, but I am showing a return of service indicating unsuccessful service as of April 7th of 2025, with a filing date of April 10th of 2025 subsequently. So I'm not sure how the court wishes to proceed on that front at this time. Although I am showing a second summons was filed with the court indicating or rather a second return of service indicating personal service on April 7th of 2025. and that appears to have been filed with the court on April 23rd of 2025.
Well, those sound different than what I saw when I looked at it earlier. Would you agree, though, that we do not have service on him?
Your Honor, the state's position is that there has been successful legal service in this matter. If the court is prepared to make such a finding, again, I am showing a return that was filed with the court on April 23rd of 2025. That same return would appear to indicate successful personal service prior to that filing date on April 7th of 2025.
All right, that's the one with the note. It does say personal service, but there's also a note from the clerk that says, I think that's a clerk's note, this summons was not issued. This should be an alias summons with the case number listed, but it appears the original summons was returned undeliverable. And when I opened that summons return, it says return of service. I received this summons on 4/4/25 and box checked unable to serve, and it's dated April 7, 2025. So it looks like it was erroneously checked as served when the return itself says it wasn't. If you take a look at that, please, Mr. Aguirre, and see.
Your Honor, if the court does have some concerns regarding any possible ambiguities, if that is the court's finding, certainly my office can issue an alias summons or perhaps a pluri summons, depending on which the court deems appropriate. But at this point, the state's position is that there has been legal service, but if the court wishes to proceed in that first fashion, the state has no objection.
Well, maybe you just need to walk me through it again, because what are you basing that legal service on?
Your Honor, the state's information is that a return on the summons was filed with the court on April 23rd of 2025.
Okay, now I'm going to stop you there, Mr. Aguirre. Now, please look at that return that was filed. Actually, open it and look at it, please. Okay. Okay. I'm looking at it, Mr. Aguirre. And it does say, receive this summons on 4/4, delivering it to the defendant personally. All right, well, let me go back and see if that is the same summons. All right, now that is very odd. I just saw one in there that said unserved. Destiny, nobody changed that file, did they?
Not as far as I understand, Your Honor, and I've tried looking into it as well. It's complicated. I'm not the clerk who left that note on there.
Well, I saw one a while ago, though, that said unable to serve. But now I'm like,
and Your Honor, what I would tell the court is there does appear to be two returns filed with the court in this case. An April 10th, 2025 return on the summons indicating unsuccessful service on April 7th. The state is basing its position on the April 23rd, 2025 summons, which would appear to indicate personal service on that same date of April 7th of 2025. And that is again filed with the court subsequently to on April 23rd of 2025.
All right, well.
And that's what I see as well as Your Honor. I'm not sure if there was an alias or if there was another summons sent out, but one summons return does say no service and the other one says personal service.
Well, since they seem a bit contradictory, I think we need to err on the side of the defendant, give him the benefit of the doubt since he fails to appear. And let's continue this to the next available date, which unfortunately, gosh, I don't want to go into October. Let's put this on the control docket September. I don't like doing this either, but September 22nd.
Your Honor, I
Yes,
do apologize for interrupting. Is the last name Ybarra?
yes.
They are in the hearing.
Oh, well, why has he been here all along? He's not saying
No,
anything.
no, I just let him in like a minute ago.
Okay, somebody must have gotten the word out. Mr. Ibarra, are you joining us now? Jesse Ibarra, if you'd click on your audio and your video, probably a little red icon with a camera and a little red icon with a microphone, both with lines through them. Jesse Ibarra, if you want credit for being here, even though you're 45 minutes late, you're going to have to communicate with me. And again, there should be, okay, you got your volume.
Yeah.
Now turn on your video, which should be the little camera with the line through it, the little red camera. Or it could be something that says start video.
Well,
Then-
it just has Zoom. That one?
Ah, there you are. There you are.
No.
You're perfect. Okay.
Sorry.
Gotcha. Stop your vehicle if you're driving. I don't do Zoom court when moving automobiles. It's too dangerous.
Okay.
Oh. Okay, sir. Well, I am glad you were here. You just helped, even though you're 45 minutes late, you helped us with an issue of conflicting summons. At this time, sir, you're charged with one count of transporting an open container of alcohol on January 16th of 2025 in Butler County, Kansas. Now that is a misdemeanor.
Okay.
And if you were to be convicted either by plea or by trial, you would be given a fine no more than $200 and a jail sentence of no more than 6 months or both. And should you get a second conviction, the court shall suspend your license for 1 year. There's no discretion in that. And the court shall demand surrender of your physical license to the court. Are you going to hire an attorney, apply for court appointed, or waive your right to attorney and represent yourself, sir?
Waive my right.
All right. And is anyone making you waive your right to an attorney?
No, ma'am. Sorry, Your Honor.
Looking at your cases filed in Kansas to see if there's anything that would, it looks like this is the only thing I'm seeing on your Kansas record as far as criminal or traffic. You might want to look into the county attorney's diversion program. Are you familiar with that?
Yes, ma'am.
Are you interested in applying for diversion to get this dismissed?
That
Kept off
would be
the record?
fine.
All
I need
right.
to.
Well, I'm not saying you need to. I'm just saying it's an option. You
Okay.
can also plead not guilty and we can set it for trial at a later date. Or you can waive diversion fees by not taking diversion and proceed with a plea of guilty or no contest and sentencing. It's totally up to you, sir.
I'll do no contest.
Okay, you don't want to look into the diversion or,
Well, I'll look into it if I have to do it. Yes, ma'am.
okay, you keep saying have to. No, you don't have to do it. Nobody's making you do it, but it's an option.
Okay.
If you pay an application fee and qualify, and then you're granted diversion and pay your fine and costs and diversion fee and whatever else they require, then they would ultimately dismiss the charge and keep it off your record. But
Okay.
if you don't want to pay all those extra fees and whatever else they require, then, you might want to enter a plea. It's just whatever works for you, whatever's best for you from your perspective.
So if I plead no contest, I don't do the diversion, or I just do the diversion?
If you want diversion, if you want to at least look into it, what I will do is enter a plea of not guilty for you at this time. You can always change that later if you want to. But to apply for diversion, you have to plead not guilty now to keep the case open. Once you're found guilty, there's no option for diversion. It's a pre-trial diversion to keep you away from trial in the court system. So that's what I'm going to do at this time, is enter a not guilty plea. But you need to get online, go online. I always tell people it's at bucoks.com, short for butlercountykansas.com, but I looked at it myself and I ended up having to just Google Butler County Attorney diversion. So look at that, and let's set your return date. If you're diverted, you won't have to come back and see me. But the next court date, my calendar is so crowded, I just cringe, literally. I don't have until October 15th. I'm sorry. If you can't be diverted by October 15th, you'll never be diverted, I say. So, all right, October 15th, 2025 at 9 a.m. You must be back here unless you've completed your diversion. And you definitely should have completed it in that period of time. If you applied today, they'll send you something in the mail in a day or in a couple of weeks, and then you'll sign that and send that back. It's the county attorney's program. So do you need that website again? BUCOKS?
No, I know where it's at.
All right. And of course, you probably know the county attorney's number, 321-6999. And I say that.
Thank you.
I say that because of your relationship to someone that used to work there, if I'm not mistaken.
Not that I know of.
Oh, no. Well, I may have the wrong guy then. All right. Well, thank you, sir. And do you have any questions before I let you go?
So you hear nothing about the case then?
Well, not today. I just tell you what you're charged with and the possible penalties and what your rights are, including your rights to a trial and the right to look into diversion.
Okay.
Yeah, if you're diverted, it'll take you and keep you away from me and away from the court system, and it'll get the charges dismissed. Now,
okay.
If you come back and we set this for trial, yeah, I'll hear all about it. And I decide if you're guilty or not guilty. But you probably won't have to play that part. All right, thank you, sir.
Your Honor. Sorry it's late. I just don't like technology.
I hear you there.
Okay.
Well, I'm glad you made it. Thank
Your
you,
Honor.
sir. Oh, wait, just a moment, Mr. Regier.
Your Honor, in light of the proceedings occurring on the record today, the state is again renewing its request for a finding of legal service, or an alternative, a finding of a waiver of service.
All right, Mr. Ibarra, did the sheriff give you a summons to be here today at some point in time?
No, all I got was a letter. This was back then, and then I was waiting and waiting what was going to go on. Never heard nothing, no summons, no nothing. And then I got the letter saying show up on the Zoom. I went, oh, okay. That's all I got. Never
All right.
do show up and
Okay.
you know, give you like a legal deal.
Okay, well, I'm gonna show them that you're here voluntarily, having waived any other formal notice.
Thank you, Your Honor.
You don't need the sheriff to show up at your doorstep with paperwork, in other words. Is that right, Mr. Ibarra?
Yes, sir. Yes, ma'am. I'm sorry.
That's all right.
I
Okay,
was talking to him too.
yeah, I got you. Okay, you may go. Thank you, sir.
All right, ma'am. You have a good day.
You too.
And you
Bye-bye.
too, sir. All right. Bye-bye.
Bye. Okay, I'm going to call Anderson, case number 2024 TR 759, State of Kansas versus Braden Thomas Anderson. Jared Regier for the state. Mr. Anderson, are you here? Mr. Anderson, we issued an alias summons for him
I
to
am
be.
here.
Okay, Mr. Anderson is here in person and pro se. That is not a moving automobile, correct?
Correct.
All right, Mr. Anderson.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and, pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case. This has been extraordinarily disruptive for court staff and the ability for them to get work done, not only in this case, but in other cases where defendants are entitled to have their cases processed and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate. A court is not supposed to, and this court will never, take into account public sentiment in making an opinion regarding its judicial decisions in cases. Courts should, and I always will, make decisions based on where the facts and the law lead me. Period. I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement. I ask that you not continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is. The executive, the elected prosecutor, is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty, nor would it be appropriate for this court to attempt to do that. This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty. My role and power in considering a plea agreement is extremely limited. My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime. That is, I can ensure what is called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant, for the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial, as had been indicated, and my staff and I were busy continuing to work on preparations to have potentially 10,000 citizens of Ada County come to jury duty starting in mid-July, with the questionnaire process in mid-July. It was, once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts that were otherwise attendant to the process of this, getting this trial potentially underway on time, and including the significant process of bringing, again, potentially up to 10,000 jurors to come in and fill out juror questionnaires prior to the beginning of the voir dire process. And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would otherwise allow for them to travel here. And so, again, I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County 4th District Marshal Service for the huge lift that they've accomplished in preparing for and orchestrating this hearing today, as well as to all the security attendant today that you see, and some of whom many of whom you don't see, with less than 48 hours notice. And so I appreciate the hard work that they've been doing. Frankly, some of them while they were on some vacation prior to the trial starting and had to call that short. And so I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the Defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment, burglary, felony, and first-degree murder, 4 counts. The state and the defendant stipulate, that is, that the defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years fixed, and that the defendant on counts 2 through 5, the 4 counts of first-degree homicide, on each count would receive a fixed life sentence, all 5 of those counts to run consecutive to one another. Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35. This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms of the plea agreement that the parties would like to make? Obviously, the plea agreement, the written plea agreement will speak for itself, will be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counter offers and answered his questions about those?
Yes.
Do you consent to the entry of the plea today?
I do.
All right, Mr. Koberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that you so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Koberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated, all right? Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime, to be enforced in the form of a civil judgment, to operate as additional punishment. This is in excess of any restitution or fines that the court could order. And again, you may be required to pay restitution to the victims of the crime. You would be required to provide, as to counts 1, 2, 3, 4, and 5, a DNA sample and a right thumbprint impression, and potentially pay for analysis of those samples. You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible consequences?
Yes.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with, that I understand you're going to plead guilty today to?
Yes.
As I indicated, I'm not bound by the plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Koberg, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision this court made, as well as your sentence?
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
Include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
You understand you're giving up that privilege and those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to have proven at trial had you, to the crimes that you're pleading guilty to, had you, if you didn't plead guilty. Let me find the document. Hang on a second here. All right. So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Madison Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice aforethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice aforethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice aforethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing at his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a PhD in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Brian Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence would include at trial video surveillance of a business on the Moscow-Pullman Highway just across the state line from Moscow that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the 3rd floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor, it was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep. During the course of this, one of those roommates awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning, so this would have been 15 minutes or so later, the defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County. About 4:48 that morning, the defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow, likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Koberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman, And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th, 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by Deputy Duke in August, it was Pennsylvania plate, no front license plate. Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Logan's body in the bed. Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office. Spartan would be a kind characterization. There was virtually nothing there. Nothing of evidentiary value was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside. And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end, the state submits that the evidence that I've given just a quick overview of, and that to present in court would consume weeks, which the state is prepared to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me, Mr. Kohberger entered the residence of 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohlberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree, as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than 1 full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in 1 day.
Defense agree with that in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July and August. The week of July 22nd is available. I don't know if that's too soon for the parties or the next week, the week of August 4 is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. Right. We've told the victims' families that we're looking at approximately those dates.
All right. So because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. We'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
No, Your Honor. Thank you.
No, sir.
All right. any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
Would have no objection for the order to remain in place through
All right,
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision at this point. We can always revisit if it seems to be, for some reason, I should. That said, obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned.
All right, please.